We had an issue in the courts with virtual backgrounds. Some of them are pretty artistic and sort of relaxing. Senator Keim has a lovely one up there, but we discovered that there was a danger of people getting coached with the virtual backgrounds on. We couldn't tell where they were, and so then we issued a directive saying you can't use them. But then the domestic violence community said to us, actually, they're pretty critical for us because we don't want other people on this video to be able to identify the premises where the person is because they may be in danger. So we have dialed that back and said again, virtual backgrounds are okay. It's, you know, everything in this COVID era is colored by COVID issues. It is an overlay to everything.
Do you need to have people keep their microphone on too, so you know that they're not being coached?
We're very conscious of that. We don't have any specific instances where we believe it has happened, but there's always that danger. Mm-hmm. And that is a concern that somebody could be off camera on the other side of the camera coaching them, but sometimes body English can give that away. So we're not aware of it, but we're trying to anticipate what may be a problem down the road. But I do love that meandering brook behind Senator Keim. That just is very relaxing.
So, you know, I am here at the brook, right? I mean,
you do some fishing afterwards, and little
you don't look cold.
It looks like the wrong season. You must be at a brook in Florida.
Yeah, I wish. No, I decided that since I'm going to, when I'm in committee, I'm going to be Zooming from like any place in my house or the state house or all these different locations. I thought I should probably just come up with one background that is just the same all the time, and you know, sort of leaves off the, hey, where's Senator Keim today? I feel like, where's Waldo? You know, that kind of thing. So I thought this might be good, but the only hard part is every time you move, your head looks weird.
Right.
Actually, if you back into it, you disappear, and then you sort of warp forward like the old Star Trek people materializing out of nowhere. Oh, you got a good one there. It's one of my colleagues disappears into the midst. My colleague Justice Gorman uses virtual backgrounds. So she has a lovely one of the Golden Gate Bridge, and as Ted will verify, that led off to a story and a song. I'm sure you can guess what it was. A whole new world. He left his heart in San Francisco.
Yes, I knew that was coming.
And I will not sing it.
So it looks like we have a quorum, and it's nice that we had a few minutes to chat. I think for purposes of how we'll run the meeting is I'll call the meeting to order, and we'll ask committee members to introduce themselves. And then for everyone else who's participating, if you could hold off on introducing yourself until your presentation begins. I think that would maybe be the smoothest way to do this. So let's see. I am going to, still don't have everybody's name memorized on the committee, so I'm going to go down. Well, actually, I'm just going to call on people to introduce themselves. So I will start with, on my screen, Senator Keim, why don't you go ahead?
Good afternoon, everyone. It is now 12:03. So my name is Lisa Keim, and I represent Senate District 18, which is northern Oxford County and 2 communities in Androscoggin. And I do have a phone call this afternoon that I have to take. So I'm going to be disappearing in 10 minutes or so, and then I'll be gone for maybe a half hour. So that's where I'm at, and sorry to walk out on you all, but it'll just be for a brief moment.
Thank you. Senator Sanborn?
Thank you, Senator Carney. Heather Sanborn, I represent Senate District 28, which is half of Portland and half of Westbrook. And look forward to joining you guys. I do have another committee this afternoon, so I'll be bouncing back and forth.
Thanks. Representative Sheehan?
Thank you. My name is Erin Sheehan, and I represent House District 12. That is downtown Biddeford.
Thank you. Representative Libby?
Hi, I'm Representative Laurel Libby. I'm from District 64, which is part of Auburn and all of Minot. And I'm sorry, I'm having trouble with my Zoom, so I'm trying to get it going on an alternate device.
Thank you. Representative Babbage?
Yes, good afternoon. My name is Chris Babbage. I'm serving in my 6th legislative term. This is my 3rd tour of judiciary, and I represent House District 8, which is most of the town of Kennebuck.
Thanks. Representative Evangelos?
Thank you, Senator Carney. Good morning, everybody. Jeffrey Evangelos, House District 91. I represent Friendship, Washington, and Waldoboro. Welcome, everybody.
Great. Representative Moriarty?
Hello, everyone. Good to see you. I'm Steve Moriarty, a retired attorney representing District 45, which is all of the town of Cumberland and part of Gray.
And thank you. Representative Poirier?
I am Jennifer Poirier. This is my first term as representative of District 107, which is all of Skowhegan and a small part of Madison.
Thanks. And Representative Downs?
Good afternoon. I'm Kathy Downs. This is my first term, and I represent District 130, which is Bucksport and Arlington.
Thank you. Co-chair, House Co-chair Tom Harnett?
Thank you, Chair Carney. My name is Tom Harnett. This is my second term in the legislature. I served on judiciary in the 129th. I represent House District 83, which is the town of Farmingdale and the city of Gardner. I'd like to welcome everybody to today's meeting, either on the Zoom or who's watching on our YouTube channel, which I'm sure has thousands of viewers by now. And very happy to be here and to hear these presentations, and proud to serve as the House Chair along with Senator Carney. Thank you.
Thank you. And I'm Senator Ann Carney. I represent Senate District 29, which is South Portland, Cape Elizabeth, and a little sliver of Scarborough. Today, we're going to have a number of presentations, beginning with the main judicial branch and Acting Chief Justice Mead, who will start things off. I would ask committee members if you can keep your video on if possible, but please mute your audio, and Justice Mead will let you give us direction as to whether you would like us to interrupt you with questions, and if you're content with people raising their hands, and then if you want questions, I'll call on people. Thank you and welcome.
Thank you. Senator Carey and Representative Harnett and distinguished members of the Judiciary Committee, thank you for your kind invitation to join you today. And we do welcome this opportunity to share some information on the judicial branch and update you on the events of these exciting 10 months that have just passed. I've known some of you for quite a few years, and it's great to meet several of you for the first time. By way of introduction, my name is Andrew Mead. I've been a state court judge for almost 31 years. I served 2 years on the district court, 15 years on the Superior Court, and I am approaching 14 years on the Supreme Judicial Court. And regarding my particular present status, the explanation of that is found in Section 1 of Title 4 of the Maine Revised Statutes, which provides that when the Chief Justice cannot perform the duties of that office, quote, the Senior Associate Justice shall perform any and all duties of the Chief Justice. So when Chief Justice Softly resigned, effective April 15th of last year, I was suddenly and somewhat unexpectedly catapulted into the role of Acting Chief Justice. It's been an interesting and challenging, but ultimately inspiring 10 months. I've been very honored to serve in this role. I'm planning on dividing this presentation into 3 discrete sections. The first is going to be an overview, basically an informational look at the judicial branch. I'll be presenting a PowerPoint to walk through that. The second will be an update, an important update on exactly what is happening within the courts during this COVID era. And then third, what I prefer to do is to save time for the questions and answers. You may have many along the way. I think that will work best because of the fact that, here's fair warning, I'm going to have to compress a lot of information into the time allotted. I'm going to be moving along very briskly. And I want to apologize in advance for the speed. But if something blows by too quickly and you make a note of it, I'd be happy to try and circle around to it at the end. I did do a dry run with this and it ran 74 minutes, so that's not going to work. I'm going to have to whittle it down a bit, which means I've got to pass over some important points, things that you might have questions on, but I really, really want to save time for the questions at the end because that is what we're here for. I am more than happy to provide you with a copy of the PowerPoint. It has lots of data and information in it. You can look at it at your leisure because I will be moving quite briskly through it. But in any event, I'm happy to always to provide you with any details, numbers, other information that may be of use to you in your duties here on the committee. We need to keep the line of communication open between the judicial branch and this committee. So the clock is running. Let me jump right on it. I'm going to take a moment here to share my screen and walk through the PowerPoint. So we'll just take a moment to do that.
And thank you for sharing the PowerPoint with us after the fact. That's very helpful as well. And we will reach out to you with questions.
Okay. All right. And I believe I have the PowerPoint up. Senator Carney, are you seeing the PowerPoint?
Yep, it's perfect.
Excellent. Okay. We've actually, here, those of us on the judicial branch have, over the last months, become educated on the niceties of Zoom. So PowerPoint's one of the opportunities there. This is an overview. The mission statement of the judicial branch is very straightforward, simple, and it guides everything we do. You are well familiar with the separation of powers. We here in Maine have avoided constitutional confrontation because everyone has been respectful of those boundaries. We've stayed in our lanes. Not all states have had that luxury, but we here in the state of Maine, I think, do it right. We're respectful of those constitutional limitations. They are of constitutional magnitude. You know this, the powers are kept separate. The court structure in the state of Maine, there are three courts. The district court and the superior court are our trial courts. The Supreme Judicial Court is our appellate court, hearing appeals from those courts. You may hear references from time to time to the family court or the co-occurring disorders court or the business and consumer court. Those are not separate courts. Those are separate dockets that we operate within the scope of our existing court structure. It's the cheapest way. We'd welcome funding of separate courts, but at the present time, those are separate dockets, not separate courts. As you probably know, the probate court is not part of the state court system. It falls under the old county court government structure. And there are many conversations going on that topic that I'm sure will come to your attention at one point or another. The judicial selection process, you know all about this, I hope. Governor nominates, posts the positions. This committee reviews the nominations and votes on confirmation. Then it's handed off to the Senate, and it requires a 2/3 vote in the negative to override the confirmation process. And many folks seem to feel that we, meaning the judicial branch, have something to do with actually bringing on new judges. We don't. We always make that very, very clear. We also celebrate the fact that judicial selection has been separate and apart from political concerns. I've explained this to colleagues in other states and indicated that the selection process has no political overarching effect on the selections here. And they ask how that happens. I explain the process and they say, well, how does it happen? I say, it depends on the goodwill of the parties. And that sends them the peal of laughter. And I say, no, you know, in Maine, we have this deep respect for an independent, unpoliticized judiciary. And this committee is right at the epicenter of that. And I thank you and your predecessors for that approach. So the judicial branch, we'll talk first about the budget. And I think we can move quickly through this. These are actually 2018 figures. We have not updated them because actually the figures are current in our books, but the PowerPoint has not been updated. This is the general fund expenditures. It is up there primarily to show you that the judicial branch accounts really only for a little over 2% of the entire general fund budget. The third branch of government really is a tiny sliver of that particular pie. When it comes to us, our expenditures, if you look at the graph, fall into two categories, which former Chief Justice Softly used to explain. We are buildings and people. We don't have any side projects or initiatives or undertakings or things where we spend the money outside. We run the courts. We have our buildings and we have our people, and that is how the money is spent. Those are our people. Those are our judges. All 63 of them. And I'll just take a moment to say what an honor it is to serve with these people. I know them all. They are deeply committed to justice. They're smart. They're compassionate. They're dedicated. I would trust anything in my affairs to any one of them. It's a pleasure and honor to be one of that number. We have 63 judges, 8 magistrates, 275 clerks, and these are our people. These are the 538 people who make the judicial branch run. Within the courts, as I said, we have 63 judges. They're split up the way you see there. We are courts of general jurisdiction. We handle pretty much everything that doesn't fall within the exclusive jurisdiction of the federal courts, or in certain instances with the probate courts. We cover it all. So there are 63 of us to cover 1.2 million people across a very diverse and spread out geographic state. This picture also is somewhat out of date. Two of my colleagues, Justices Hyom and Alexander, have retired. We've added 2 new justices, Justice Horton and Justice Connors, for a total of 6. We have 1 vacancy pending at the present time. And also, obviously, Chief Justice Softly has left to become the Dean of the University of Maine School of Law. She had entered into that contract before COVID hit. She was duty bound to move out. And we have had a number of conversations since then, but she would very much like to be on board with us during this crisis. But she was contractually committed to move to the law school at that time. I do want to give a shout out to the trial court chiefs. Each of them is the head of their respective courts. They are part of the 6 of us who are sort of at the top of the administrative structure we're working with right now. Chief Justice Mullen of the Superior Court, Chief Judge French of the District Court, and Deputy Chief Judge Lawrence of the District Court. They are working day and night to keep things running, and it is an honor, again, for me to serve with them. Superior Court justices, it's not up to date. We've had some vacancies and some new additions. Again, 16 justices who preside in the Superior Court, which includes jury trials, to cover all court locations and 1.2 million people. Our district court judges are our frontline judges, day in, day out, dealing with the most difficult circumstances, protective matters, family matters. They are a profoundly committed group of people. They're dedicated to what they do. And as I said before, I would trust my affairs to any one of them. Our district court magistrates are actually engaged by the court, and they serve to look at all of the family matters that come into the court, parental rights actions, divorce, custody, things like that. They meet with the parties, attempt to find middle ground, and they do a marvelous job of resolving cases before they actually come to the contested and potentially destructive format that is a trial where they go one-on-one. We are deeply grateful for their efforts, and they have really leveraged the video platform. It turns out it's a very effective platform for mediation. Folks who are not comfortable being in the same room with each other are finding that they can participate in a calm and appropriate manner. Ted Glessner is our state court administrator extraordinaire. I know he's on this call and he's going to hate me saying this, but we think he clones himself, because there's got to be 4 of them, because he is everywhere. He does everything. He has an encyclopedic knowledge of the judicial branch. Absolutely vital to what we do. Thank you, Ted, for what you do day in, day out. And nights too. I get emails and communications from him all hours of the day. Our clerks of court are vital to what we do. They're the ones who meet people at the window. They talk to people on the phone, people who are often not happy about what is going on, and they have marvelous people skills, marvelous organizational skills. They are the ones that keep things running on the ground. And again, we are deeply indebted to them. Our judicial marshals are the point of contact, first point of contact for people coming into the courthouses. They have a very difficult job. They now are our entry screeners. They are the questioners, COVID questioners, the temperature takers, and the individuals who occasionally have to turn people away from the courthouse. It's an extremely difficult job. We don't have enough of them. I'll talk about that later, but we are indebted to them and their professionalism. Facilities, I won't take a whole lot of time with that, but I will mention that over the last years, we have undertaken a massive project to consolidate courthouses, to modernize them, take them from basically 19th century designs into safe, efficient, open, and productive workspaces, consolidating courts, often taking district court, superior court, putting them in one building. The dates are there. We're delighted with the new fabulous facilities, and the York Judicial Center is in progress, scheduled to open, fingers crossed, in 2023. We have 8 judicial regions across the state. They're color-coded here. Courthouses designated, and they each has its own administrative process that I'll talk a little bit about in just a moment. The history of the facilities, just simply throw it in there to say that we started out in 1820, and basically courthouses were taverns. I'm sure they had some interesting goings on, court proceedings back in those days, but that ramps us up to where we are now, where our courthouses are in fact the courthouses of the future. They'll serve us well into the 21st century. Facilities, it boggles my mind, but until 2002, we had no entry screening. We're up to about 70% before COVID hit. We are looking for more marshals. That effort is underway, but even if we get the positions, there are substantial challenges with recruitment. I'll talk about that more in just a moment. And I'll show you some pictures of some courthouses around the state. You can look at your regions and as they pop up. York Superior Court is going to be consolidated into our New York Judicial Center coming soon to York County. Cumberland County has the imposing concrete and steel facade next to our colleagues in the federal court. Their building is right next door. Inniscalgan, Franklin, and Oxford, largely older courthouses. The Lewiston District Court was revamped and is working much better there, but some efforts underway in those courthouses. Kennebec and Somerset on the upper left, you see our brand new Kennebec County Superior Court, which is housed in the Capitol Judicial Center. Wonderful place. I hope you get a chance to visit it. It's where we convene one of our experimental jury trials. Penobscot and Piscataquis, the Penobscot Judicial Center, one of our new buildings. It's where I am seated at this very moment speaking to you from. It's modern, it's open, it's safe, secure, and efficient, and at the other site where we conducted successful jury trials. Knox, Lincoln, Saginaw, Waldo County just undertook a major new courthouse project, and folks down there are absolutely delighted with it. It's playing to rave reviews. Hancock and Washington, Washington County, Machias Courthouse got a makeover, modernized. Hancock, we're still taking a look at. The layout is a little challenging, but that is going to be a work in progress. And finally, Aroostook County, consolidating the Superior and District Court in one building. It's a progress, it's a process, but we are slowly making our way into the 21st century. Technology is so much to talk about here, but I'm going to simply focus on a couple of points. We have implemented our e-courts system. We previously had an outdated and ineffective technology in our MEGIS case management system. Over a 15-year period, we have created a new paperless system, which we call Odyssey. That's the case management system, and implemented an e-filing system where folks will be able to file things electronically. There will be no paper records. Everything will be an electronic record. It was implemented. It went live in November of 2020 in Bangor and for the business consumer docket for certain case types. E-filing went live shortly thereafter. It is it's a pilot project. It's a shakedown cruise. We're seeing what works and what doesn't. I've been on board with this from the start, and I'm delighted. We're headed in a very, very productive way. We will have CMS and e-filing implemented across the state. We're targeting the end of 2022, but it's an organic process. We will aim for that. So far, we've done pretty well, but it is a huge, huge process. It changes how we do what we do. I want to talk about video remote briefly also, interpreting. Prior to maybe 5 years ago, we didn't have a consistent method for interpreting for LEP folks or hard of hearing folks. 2 years ago, we enacted a language access plan, very ambitious, very detailed. Happy to share it with you if you want. We just renewed it yesterday, actually, and it is working very well. Our LEP folks have access to an enormous number of languages, and our ASL users, we're finding that remote video proceedings are working extremely well. It really is kind of made to order for those particular proceedings. Improvements and innovations. I would like to talk to you about every one of these things, but we simply don't have the time. But we, over Chief Justice Sofley's administration, one thing after another, looked at it, took steps to improve it. During the COVID era, we have not stopped that. We are still innovating, improving, inventing in the process. If any of you have particular interest on any of these topics, I'd be happy to circle back and talk about any of them. So the final slide says thank you. Thank you for letting me present to you, but also to thank you for your indulgence in me going 100 miles an hour through this. We will make the PowerPoint available to you after the fact, and there is some additional information there that I think you'll find helpful and worthwhile. So with that being said, I want to jump right ahead to some important points I need to talk to you about. I want to explain where we are, what's happening here. I think that's probably the main topic of interest to you. But to understand where we are today, we really have to understand where we've been. So I want to give what I hope is a brief overview on that. I don't have enough time to hit everything. I've told you before, this is the short version, but I will save time for questions because I think that's what's important. The challenge is, we haven't written this down, but we invoke it every time we look at every issue that's come up over the last 10 months. The challenge is, and always has been, to balance the safety of the public and our people with the critical need to keep the doors of justice open to the maximum degree possible. That, we don't have a mission statement, but that sentence guides everything we've done. To do that, we've reinvented almost all of how we do what we do. In the process, we've been guided by the science, by the numbers and consultants. We have consultants at the CDC, and the need to first address priority cases. Those are cases that involve constitutional liberty interests and the danger of people who might be in danger of being hurt or even killed. Those are priority cases. They get the first shot at our time and resources. We have taken stock of all of our resources. We have sought and welcomed input from stakeholders. So taking you back to the dark days of March and into April, we had no idea what was hitting us. We had no idea what it would bring. We knew it would be bad. We convened an excellent leadership team. I've mentioned before, Chief Justice Mullen of the Superior Court, Chief Judge French, and Deputy Chief Judge Rick Lawrence of the District Court. Acting Senior Associate Justice Ellen Gorman, my colleague on the Supreme Judicial Court, Ted Glessner, our court administrator, and me. The six of us have been meeting almost every day. We communicate every day, interminable meetings. Luckily, all six of us have a good sense of humor and are able to work together. It's a pleasure and honor to work with them. We have developed innumerable innovations for presentation and implementation by the SJC. To start with, we substantially restricted all courthouse operations. We went almost completely dark or open only for those priority case types that I talked about, and open for filing petitions for protection from abuse, child protection. We vacated arrest warrants. We tried to set personal recognizance bail in all cases that didn't require cash bail. And we cautiously reopened the courthouses. We had staggered staffing so there wouldn't be unnecessary people overlapping during the course of a day. We undertook a comprehensive, and I do mean comprehensive, review of historical usage numbers for each location. And we computed the minimum numbers of staff hours necessary to run them. We created entry screening protocols. We imposed safety measures with guidance from the CDC, masks, face shields, plexiglass barriers, hand sanitizer, air purifiers. The list goes on. We mapped every courtroom in the state of Maine for capacity controls and seating markers, capacity controls posted outside the doors. We imposed a number of in-house policies. We required clerks and administrators to work at home if possible. Many workplace policies and directives were revised, but today I'm just going to stick mostly to the public-facing aspects of what we've been doing. We started scheduling out 1 week at a time. That's all we could do. We gradually moved to 2 weeks, which was a big step for us at the time. But in the meantime, we issued a series of ad hoc administrative orders, and it became obvious to us that we needed to archive those and organize them. So we created an animal called Pandemic Management Orders, PMOs. The benefits were that we expedited drafting and the promulgation process. They're quick and easy to revise, much easier than rules, and we've had multiple occasions. Every one of these has been revised numerous times. The devil's always in the details when you try and invent something new. It looks great, it gets out there, you test it. There are numerous tweaks, fixes, and adjustments necessary. These PMOs supersede our existing court rules and administrative orders. We are basically rewriting all of those rules. We convened a stakeholders advisory group. We collected comments, held public hearings, and I have on my shelf over there a massive 3-ring binder archiving all of the ways that COVID has adversely affected people and organizations that rely on the courts being open. And some of them are very compelling comments. I mean, some real hardships are taking place out there. We continue to have open communications with the stakeholders. Some of those hardships have been easy to fix. We've done so. Some are taking a little more time, and some we just can't fix. We have revamped our website for easy use of the public. We've got everything on it. I really encourage you, if you have an opportunity, to take a visit to the Judicial Branch website. There's a COVID banner with everything we're doing about COVID, PMOs, statements, and all the rest. But as April rolled around, it became obvious to us that we needed some long-range planning. And on May 2nd, after some very intensive work, we issued our COVID-19 phased management plan. It had 5 phases that sequentially allowed us to add additional case types and specific proceedings to specific court locations. And it's gone through a number of revisions since that date, the most recent being November 3rd. Each phase of the plan had 2 objectives. First, each phase allowed us to ensure that our COVID containment measures were adequate. We received CDC approval each step of the way, along the way. They felt our measures met or exceeded their requirements, and it allowed us to prepare our facilities and create new procedures for these case types that will be rolling through. As I said, we basically rewrote the rules of civil and criminal procedure. It was a massive undertaking. It was an ambitious plan. It anticipated being fully completed by October. My hope and belief, as I said to some of you, was that by October and November, all cases types would be being heard. Jury trials would be underway. The summer of 2020 was consumed with intensive work and efforts, including all hands on deck approach to the challenges. We had working groups for facilities, jury planning, and all the rest. And so the public view, the public facing appearance of the JB may seem subdued, but it was indeed a beehive of activities. We set up committees to look at all aspects of the JB operations. I can go through those committees. I'm going to jump over them, but basically everything we did had a working group with people dedicated to come out with new ways, new innovations to keep the courthouse doors open to the maximum degree possible. So as summer moved to fall, we had done everything we could to keep our facilities open. We had drafted procedures for all case types as they became eligible for hearing. We successfully conducted jury trials in Bangor and Augusta. As I mentioned to some of you before, we were able to do that in those locations because they are large buildings. They have multiple courthouses. They have large multi-purpose rooms. Some of our county courthouses simply lack those capabilities. But As of September, we were optimistic. We realized, however, that with building capacity controls, we couldn't do our traditional large docket calls with large numbers of people appearing. Some county courthouses simply couldn't accommodate those numbers of folks coming through the doors. It was really one of the tools how we managed our dockets in the past. Video remote is evolving. The process takes time. I can talk more about that later if you wish, but we're getting really good at that. One of the biggest impediments to moving forward was lack of judicial marshals. Before COVID hit, we didn't have sufficient numbers for entry screening everywhere. But now, if a courthouse is open to the public, we need to have entry screeners. They have to ask the COVID questions. They have to take the temperatures. They have to possibly deny entrance. And marshal qualifications, as you may know, are established by statute, requires Criminal Justice Academy, and the numbers and the budgets are approved by the legislature. But the bottom line is we can't keep all courthouses open at all times because we don't have enough marshals. And as you know, jury trials are marshal intensive. And to make matters worse, even if we receive new marshal positions from the legislature, and we are trying, it's difficult to fill them. It is difficult to get new marshals. I can talk about more about that shortly. So we're up to November, and some cold realities are staring us in the face. Numbers were going up. On November 3rd, we issued a revised pandemic management plan that included an addendum. And in brief, it is this: the priority cases currently fill our dockets. We cannot predict when the other matters may be heard. And jury trials at that point would be limited to criminal matters, no civil jury trials. I set the trial court chiefs to working on a schedule for jury trials in 2021. I also issued a detailed statement on November 3rd regarding the obstacles and the path forward, and both are available on the website. I really commend them to your reading. The pandemic management plan, the addendum, and my November 3rd statement. It will bring you up to date on a lot of things that I can't cover here because of lack of time. The stark reality is we simply can't get back to business as usual while the COVID threat is present. We're stuck with the limitations of our currently existing resources. This situation isn't unique to Maine. It's happening in many, many other states. I could run a pile of facts and figures before you. I'll just hit a couple in passing for reference. At the present time, as of January 19th, the adult criminal active pending caseload was 22,395 active pending cases. And that is to be compared to December 31st of 2019, when there were 13,113. So almost a doubling of pending cases. Also mentioned that as of the present date, there are 52 murder cases pending. At 2019, at the end of the year, there were 40 murder cases pending. I mention these because those of you who practice know that murder cases can create a logjam. When we schedule a docket of criminal cases, there's a long list. If there's a 2-week murder trial at the top of that, we know as a practical matter, none of those other cases are going to plead out because they'll wait and see what happens there. That's just the way it works. The civil cases have remained within expected norms, but they are pending. And I'll mention that the foreclosure caseload, those pending over 1 year old as of January 19th, 2021, there are 1,127 active foreclosure cases pending. So, as with any information within the judicial branch, if the committee wishes further information, data, figures, we are more than happy to provide them to you in the process. So here's where we are. Because COVID numbers are going up dramatically, we are either at the peak or approaching the peak. Here's the way it looks for us. Jury trials are on hold indefinitely. As I said, not all facilities can handle the jury trials. We'd like to get back to them, but at the present time, priority cases are filling our dockets, both the in-person dockets and the Zoom dockets. We find this deeply distressing and extremely frustrating. On the brighter side, Our remote video capabilities are really becoming fully involved. We have Zoom licenses obtained and deployed for all judges and clerks. We've had extensive in-house training for all judges and clerks. We want all judges to be able to host Zoom proceedings like I'm doing here, to be able to use the screen to host the proceedings. We have obtained and deployed Zoom carts in all courtrooms for the state. It's a standalone unit with a rolling cart, has a big screen TV at the top, and a dedicated Zoom server, and they are playing to rave results. Everyone thinks they're terrific. These have been major technological challenges. I have some detail here on what we had to do to get from there to here. I'll skip over it unless you want those details, but I think the bright side may be, even after the siege is over, we're going to be very competent in handling video proceedings. It actually works better in many settings. We've created a COVID pandemic status monitoring system, and Amy Quinlan, who's on this call, is at the epicenter of that. It collects numbers and data for all court locations throughout the state, presents the materials and briefing once a week. There are color-coded graphs, charts, and specific closing protocols. We have authorized our regional judges in consultation with the chiefs to make those decisions. This is a significant step forward because this gives us the ability to address specific geographic locations and specific courts for closing all-time, part-time, unlike before when we had one size fits all. We had to open up or close down the state. So we will continue to innovate to the maximum degree possible to allow court operations to safely take place. For example, I'll just throw one out there. We recently approved emailed court filings. This allows people who in the past would have had to send things to the court, now can email them. You don't have to come into the court to file, you don't have to mail, you don't have to go to your office. And this applies to the profession, to lawyers, pro se filers, and it's been met with great appreciation. Keeps people out of the courthouses, and we may keep something like it after the siege is over. I mentioned briefly the eCourts Odyssey system. It's up and running. We've completed 11 training sessions, total of 716 participants. We look forward to when it is fully implemented. I kind of wish it had been implemented before this thing started. We'd be in a different place. But it will be in place throughout the state before too long. We have a brand new, fully reorganized judicial branch website. Everything about the judicial branch's response to COVID, easy to navigate, everything the public needs, everything you need, you can find right there. Please visit it if you have the opportunity. We continue to roll out PMOs with innovations. Last week, we issued a PMO that reorganizes how police departments summons. In the past, they just summons for the next available date. We were finding courthouses overwhelmed with more summonses than the capacity controls allow into the courthouses. So we created a massive grid and schedule for which departments can summons for what location. That went out last week, and that's going to make things much better. I'd like to list all the innovations, but we don't have time to do that. But I do want to take time to pay tribute to the 538 employees of the judicial branch and their commitment to provide meaningful and safe access to justice. They're an amazing team. They are dedicated. It's just an honor to work with them. In conclusion, this has been a wild and exhausting ride over the last 10 months. We share the deep frustrations of those many people, your many constituents, who are waiting for their matters to be resolved in court. We exist for the purpose of providing peaceful resolutions to human conflict. That's what we live for. And it tears our hearts out to be hobbled by this. But, you know, we're not like a theater or a restaurant. We can't simply shut down and go dark. The doors of justice have to remain open, safely open to the maximum degree possible. This we have done. This we are committed to do until this terrible siege is over. So again, with apologies for the speed of this and for the points that I've jumped over, I want to thank you, chairs and distinguished members of the committee. There's much more that could be said. I am available for questions. Thank you very much for your attention.
Thank you so much, Justice Mead. You did, first of all, you covered a lot in 45 minutes, but you also obviously as a branch have accomplished amazing things since March. Thank you for all of your hard work, making sure the courthouses are available, especially for those high priority cases. And I'm going to call on committee members Please raise your hand and kind of wave it around by your face because it's easiest for me to see amongst the squares. And I see that Representative Babbage has a question, so he can start, and then Senator Keim.
Thank you, Madam Chair. I realize that asking questions will prolong the afternoon, and I could keep Justice Meade here for weeks to pick his mind. So first of all, thank you so much for all you've done in your elevated position, and we appreciate your efforts greatly. And it's very exciting to hear some of the progress you're making at a difficult time.
Thank you.
There are some concrete questions that I would like to ask, but I'm just going to ask one at this moment. The foreclosures that you talked about, 1,100 active pending cases, given the governor's orders and the new president's executive order that went out yesterday, that has dealt with foreclosures. I was wondering if that 1,100 number has been increasing during COVID, or was that a pre-COVID number? Or I'm trying to understand the magnitude of our foreclosure issue here in the state.
My understanding has been a slow increase. I'll get you those exact numbers if you wish, to the extent the new cases have been filed during the COVID era. I should point out with that number, with those foreclosures, in at least half of them, I know that there are issues that place declarations of bankruptcies and other things that have slowed them down. We also, as you point out, have been subject to orders and directives both from the state government and from the federal government, and apparently there will be more coming that we're trying to sort out. There is a practical obstacle to them also. They're not in the top level of the priority case. The priority cases are set many years ago, but civil cases, so there's a practical impediment to them being heard at the present time, which we need to factor into all of that. I will get you those numbers on how many are new and what the trends have been in the meantime.
Thanks so much.
Senator Keim?
Thank you, Madam Chair. I actually have several questions. So what I think in the interest of time might be best is if I ask them and then possibly you just send us an update on them rather than answering them all now. It might be just easier. Thank you for being here. I appreciate the update. One of the things I am also concerned around the foreclosures, because I'm hearing from a lot of people that can't get them handled, and the amount in the foreclosure has been suggested to me that it's going up a lot. So when you include that information for Representative Babbage, if you could also give us some idea on that as well. What I'm hearing from my landlords is, they're going to lose their home while they keep everyone else in theirs. So that's one question, and then. Would like to hear just a little bit of an update on the York County Courthouse and the housing the DA. And again, that's not necessarily something you have to address right now, but I know it's for anyone that's been on the committee before, we've heard a lot about that. And you mentioned the prioritization of issues, and I know that it's constitutional issues that had to be prioritized, or specifically those during these times. And I was wondering if there were any cases that came before the courts regarding people who refused to quarantine, if that was any of the sort of liberty issues that had come before the court.
Sure. Regarding your first questions regarding foreclosures, and I think you also referenced evictions in there, what I'll do is I'll provide those numbers to either Peggy or Susan and have them circulate that to all of you. That's probably the easiest way to do it there. I should mention on the evictions, again, there have been dictates coming from state and federal government. And I also get the letters I think you're getting too. I get heartrending letters from, I got a letter just a couple of weeks ago from a woman who owns a duplex, and she is 63 years old. It is her only source of income, the rental next door. the tenants have stopped paying rent. They're treating her with verbal abuse. And it was absolutely gut wrenching. And I wrote back to her and said, you know, I've received many other letters like this. It tears our hearts out too. This shouldn't be happening. We will continue to try and innovate, but we're in a state of hold right now, but we'll try and get the numbers to you on foreclosures and evictions. Regarding the York County Courthouse, the earth has been turned, the construction is taking place. We are nailing down some of the final aspects of the structure, particularly related to energy. I'm a late comer to this. I believe that the conversations with the district attorney's office have taken place. I will get that answer for you and provide that again to the committee because you want to know about that. And did you have another question in there? Was there 3 questions in there? Have I missed one?
Yes, and I actually have 2 more.
Okay.
So the one I already asked was about just if there was anyone if there were any cases that had come before the court regarding refusal to quarantine around Liberty, and then one other question after that. I'll just let you answer this one, then I'll ask the other.
We haven't had any cases that I'm aware of regarding failure to quarantine. I don't know if you remember, but when the pandemic first hit, there was a law or an executive order passed about people being arrested for going out and contaminating other people. I haven't heard of anything happening with that. And again, I'll query my colleagues to see if they're aware of anything, but I think the short answer is no, at least as far as my knowledge goes.
So, and then my final question, thank you for your patience with me. You mentioned at the outset that during the pandemic that we have all stayed in our lanes and, mentioned the constitutional separation of powers. So one thing that I hear constantly, and I have not ever found a good answer for, is the idea that right now the legislature is basically giving over our powers to the governor. And with Article 3, it would seem that is unconstitutional. So can you, and if this is too long of an answer, maybe you can just direct me to a place where I can find this information, but I would like to hear more in depth on the legality of that.
Actually, I can give you a short answer to that one. Because that is an issue that it is possible and probably likely to come to the court at some point, I can't offer an advisory opinion. It's going to play out. We're in unprecedented times. And I guess the short answer is I don't know the answer because it's going to play out. And eventually, if it comes to the court, we'll address it. But you put your finger on a very hot topic. And as with any issue that we can see looming on the horizon, I can't give anything that resembles an advisory opinion. So I'm going to have to apologize that I can't address it specifically.
Thank you.
Thank you.
We're nearly out of time. Representative Evangelos has a question, so we'll let him ask his question. And then I would also ask if Mr. Glessner and Ms. Finn and Ms. Quinlan can all take a turn of introducing themselves as well after Representative Evangelos completes his question.
Sure, I'd love to have them make their presence known.
Okay.
Representative?
Actually, Representative Evangelos, is it okay with you if we do that first?
Well, I do want to point out that, we are the oversight committee for this branch of government, and this is just not an adequate amount of time to be discussing this with the Chief Justice. So I would ask that he reappear at another time if we can't ask questions. I don't care what order you proceed in, but we have some serious questions asked today. We were told we could ask questions, and the time was reserved for it. And I want to ask my questions.
I will come back as many times, as often, and whenever you wish. We need to keep the lines of communication open between the JB and this committee.
Yeah, thank you. Do you want to, Representative Evangelos, would you like to begin with a question now, and then we can
Sure.
schedule additional time?
Well, I do. I have several areas of inquiry, and they're important. And if you want to cut me off, it's a prerogative of the chair.
Well, let's get started and see if we need
Sure.
to make arrangements.
Justice Mead, thank you very much. You and I have spoken in the past. First question is, and it's a simple yes or no. Have you read the Sixth Amendment Center report?
I believe I have, yes.
Okay. And will you assure me that the rest of the justices, district and superior court, are directed to read it?
I will assure you, I can't say retrospectively, but I'll say prospectively, yes.
I did want to point out to you that the separation of powers in one period of time in our state prior to the election of the current governor were routinely violated by that governor. And we don't have to get into it any further, but I do want to point out to you that we did have separation of powers issues with Governor LePage. I also wanted to point out to you that your own Supreme
Representative Evangelos, can I just interrupt for a moment? This is a question, an opportunity for you to ask questions of the Chief Justice. Sounds like you're getting more argumentative. Maybe this is more appropriate for a work session on a bill, but go ahead with any additional questions you have, please.
Thank you. You are also aware that Superior Court Justice Martin was found to have violated the constitutional rights of a criminal defendant. Did your Supreme Court make that finding?
I'm aware of all the public findings regarding all justices. Yes.
Okay. So, in reference to the reforms we're attempting to enact, and the reason why this discussion is so important is that judicial and criminal justice reforms are sweeping the nation because of the tragic events we've been witnessing. And we're making a good faith attempt and effort to address those areas in both the Criminal Justice Committee and the Judiciary Committee. And I've had 2 sidebar conversations. You generously gave me your time in the last 2 years. And it revolves around post-conviction reform in Maine, allowing an incarcerated individual a little bit better, a more, I wouldn't say liberal, but a better chance when new evidence emerges to obtain a hearing like they do in 35 other states. And your comment to me both times I asked you was, we need to get this fixed. That's a prerogative of the legislature, and you respected the separation of powers. But you mentioned to me that we need to get it fixed. So I just want to point out to you, so we can get some help going down the road, that when we submit these bills, the wonderful representative for the courts that comes into our room, and we all like her very much, but she presents testimony to us that says the courts lack adequate resources to take these kind of things on. Now, if we have the adequate resources to incarcerate people, we've got to have adequate resources to free them when they're innocent. So I just hope in the future, when this testimony is delivered, that serious topic is taken into consideration and we don't get pushback from the court in regards to trying to make these reforms. We have to have the resources. If we can put people in prison, we've got to have the resources to get them out if they're innocent. So can I have your assurance that we'll get a little more help there?
Senator, Representative Evangelos, and I'm sorry to interrupt here, but we do have, our committee will be hearing a bill, and I think that this is a really important discussion and will be really appropriate for us to have in the context of that bill.
And we certainly are welcome, are
understanding.
willing to offer input, assistance, expertise, whatever it takes.
I have a couple of other brief questions. May I ask them or not?
At this point, what I'd really like to do is to give the other members of the judicial branch who took the time to be with us today an opportunity to introduce themselves. And again, I do think that Justice Mead has expressed his willingness to appear at another time and answer questions. And I think that's a better route to take, given that we can reschedule him for another time. And we've got lots of folks who are here waiting for their turn, which begins in 2 minutes. So let's move on with the introductions by other representatives of the judicial branch, and we'll schedule another time later for additional questions. Thank you. Let's see. Julie, can we start with you?
Sure. Thank you, Senator Carney. My name is Julie Finn, and I am a person you will see quite frequently in front of the committee. I am the judicial liaison and legislative analyst for the All Matters Legislative. So it's a pleasure to meet those of you who are new to the committee, and it's wonderful to see those of you who are returning. Thank you.
Thank you. And Mr. Glessner?
Thank you very much, Senator Carney and members of the committee. I'm very pleased to be here and have an opportunity to say hello to folks I've known for a long time and to get to meet people that I haven't met before. I've been in my position as Maine State Court Administrator for over 28 years, and I just want to say that we've never had a more difficult task than we have right now, dealing with the implications of COVID, as Justice Mead has explained them to you. And I too am very, very proud of the people in the judicial branch who have done so much to make the changes and to adapt and to try to address this issue of justice while at the same time making sure that we keep people safe. So we thank you for your support and appreciate the opportunity to work with you. Thank you.
Thank you. And then Ms. Quinlan?
Yes, thank you, Senator Carney, and thank you for allowing me to join the group. I am very grateful to be here and to meet all of you. Some of you I've met before. I am the Director of Communications, which includes the legislative piece, and I work with Julie on that, as well as other media issues and court communications. I've been with the Maine Judicial Branch for a little over a year, most of which has been virtually. But I join you from Delaware. I was the former state court administrator for that court. So thank you. I'm glad to be here.
Thank you very much. And again, I know that we have more to talk with the judicial branch about, and we will take that up at another time. Thank you all for being here today, for all the preparation work you did, Justice Mead, and for your really excellent and thorough presentation.
Thank you.
You're welcome. At this point in our agenda, and you're welcome to continue to participate, although that of course is not mandatory. But at this point, we're going to move on to our next presenter, and it is the Office of the Attorney General and Attorney General Aaron Fry, who I believe was on a short while ago, and I don't, oh yes, he's waving his hand, which is really helpful among the sea of faces. Thank you. I am going to turn it over to the Attorney General.
Senator Carney, thank you very much. Representative Harnett, members of the Judiciary Committee. I hope you can all hear me very well in this COVID-19 times. I always wonder if my mute is off, so I hope my mute is off. And I appreciate this opportunity today to introduce myself to those of you that I have not had the chance to meet yet, and to spend a little bit of time with those of you that I've served with and have had the opportunity to spend some time with. I hope you've all received the overview that Mark Mallon, my government relations person, had sent over to the committee. I think that there's a fair amount of information in there, so I might sort of more briefly cover some stuff, recognizing that I provided some direction there. I also appreciate that I have a half an hour. You have a long day ahead of you, and I want to make sure I have some time for questions. So first, as you all know, the Attorney General is a constitutional office. It's found at Article 9, Section 11 of the Maine Constitution. Not a lot provided for what the office is to do. All that the Constitution does is say that the Attorney General exists and how the Attorney General is elected. It's really as you get into statutes that the legislature over the years has identified, what it is that is expected of the Attorney General in terms of the types of representation and defense and actions that the Attorney General is to take. And so what you see in the overview is a link to the statutory section, so that the statutes for the Attorney General are found at Title V, Chapter 9 of the Maine statutes. And you work to those statutes, you see that very generally the Attorney General is responsible for providing legal representation for the state, in particular the agencies of the state. So if you are a state agency, you should be receiving your legal services from the Attorney General's office, or under the direction of the, under the supervision of the Attorney General's office. So very commonly, this includes attorneys working with state agencies, whether it be DEP or your natural resource, your marine resources, or the governor's office, or the legislature from time to time. The judicial branch from time to time has accessed services through the Attorney General's office. There are times where there might be some conflict that comes up. So for example, if there's an issue between the legislative branch and the executive branch, and both need legal services provided, then there would be some opportunity for the Attorney General to authorize outside counsel to make sure that everybody got the fully zealous advocative legal services that they deserve in their actions. So when I say that either the Attorney General's office is representing, or it's sort of under the supervision or under the direction of the Attorney General's office, it recognizes that there are times where multiple counsel might be needed, and to reduce conflicts, some opportunity for representation might be set up. What you also see in the statutes are different actions that are specifically entrusted to the Attorney General. I'm going to touch upon those when I do a brief walkthrough of the divisions that the office has. I also want to point out, and I reference a case in the overview. I've just talked about the statutory framework and what's specifically enumerated for what it is that the Attorney General's office is responsible for, needs to pay attention to, what actions may be engaged in. But there is still common law authority that the Attorney General's office has. So you look at the office of the Attorney General historically, it dates back to, I believe, the 1600s England, where there was a general counsel, an Attorney General that had certain reserved powers. That office pretty much traces up to the current day. So there's some activity, there's some reservation of authority that the Attorney General has in order to ensure that she or he is able to best represent the interests of the citizenry, right? So the case that I put, that I made sure to include, it's a preeminent case. It's a leading case on this question of authority that the Attorney General may have. It presented a situation where there was an agency of the state that was doing something that the Attorney General just did not think was in the interest of the citizens, right, of the citizens of Maine. And so it was a situation where the agency did get representation, but the Attorney General was able to put their own, take its own position in that litigation. So I point that out because there is that history, there is that common law root of the Attorney General's office that certainly not for as long as I've been in office, but we do see bubble up from time to time when there's an important issue that perhaps the Attorney General comes down in a different place than the agency or the represented party might land in. Let me also add that there are different types of actions that the Attorney General is specifically empowered to bring. The two that come to mind are unfair trade practices. So the legislature has directed the Attorney General to be able to bring actions to support consumers who may be the victims of an unfair trade practice. I believe there may be one or two of you who have constituents who are wrapped up in a building contractor issue that came to light about a year and a half ago. The Attorney General's office came in and has brought an action against that building contractor, for really what amounted to an unfair trade practice. That was authorized by the legislature. That type of action was authorized. Additionally, we bring civil rights actions. Over the last year, in fact, we've brought 3 where we see a particularly egregious type of civil rights action, whether it be a suspect who is engaged in a very significant racial animus or based on some sort of activity based on ethnicity. when you have a suspect who's engaging in that kind of behavior and it's putting somebody else at risk, putting somebody else in fear of risk, chilling that individual's free participation, free protection of their civil rights, the AG's office is authorized to bring those types of actions. I think probably for many of you, when you interact with the AG's office, it's going to be on different questions that you might have that we may be able to help you with relating to legislation and whether or not it's something that's currently covered by statute, if it's something that would survive a challenge if it moves forward. You may have constituents that have questions that you think are appropriate for the office that you call up and engage upon. I know there are some of you who have taken advantage of that open door, and we've been able to talk about various things, whether it be, you know, the lobster rules that are in the lobster litigation that's being engaged in on the federal level and at the state level, on the opioid crisis, on foreclosure laws. There is a lot of activity that occurs between this office and members of the legislature on questions like that come from work that you're doing or from constituents that have questions that might touch upon the AG's office. Going to try to do a brief walkthrough of the divisions that the Attorney General's office is broken up into to compartmentalize the work, if you will. Those divisions, of course, are listed in the overview. Administration, that's pretty much as it sounds. That really is the division that helps me manage the office. So make sure that we're keeping to the budget, making sure that we're hiring people, making sure that personnel issues are being addressed. You know, these are all different types of activities that the administration division helps. Our IT, our OIT type work, that's where the administration division is focusing its efforts. We have a division that's focused on our child protection work. So we have we are responsible for representing the Department of Human Services, the Child and Family Services. Whenever there's a child that there is an allegation that child is at serious risk of abuse or neglect by a parent, then the Department of Health and Human Services may bring an action to protect that child. And so the parents have rights, child has rights. The state has an interest in making sure that parent-child relationship is safe and that the child is safe. So we have assistant attorney generals in the office who represent the state in these actions, who, you know, they represent DHHS, but they also make sure to work with the parents' attorneys because, you know, the interest here is to make sure that the child has a safe place to be, that the parent-child relationship, you know, that's a constitutionally protected relationship, that's protected as best as it can be so long as the child is safe. So the Child Protection Division is really responsible for making sure managing the legal needs of the department in these child protection actions. There's also a child support division. So we have child support. Similarly with the Department of Health and Human Services, there's child support enforcement. We represent child support enforcement to make sure that parents who are obligated to pay for the upbringing of a child that they may have parented but are not, they do not have a custodial relationship over. This is the typical situation where you might have a single mom or dad who is taking care of a child. There's another parent who is not providing care but should be providing, you know, financial support. We have attorneys in the office who work to ensure that parents who are responsible for paying do pay, and when they are not paying, we engage to enforce, to collect, to work to see that money come in. And that's a service that it may be because there's a state service that's being accessed, so temporary assistance for needy families, food stamps, Aspire. There may be some program that the single parent is accessing. The Child Support Division is able to help get resources that then that really defray the need to access those state programs. But there are times where, when asked, this office will engage to help enforce a child support order, regardless of whether or not there's a state program that's being accessed. A division that probably many of you either have or may take some interest in through your legislative service is our Consumer Protection Division. It is a very active division. It's the division that covers the opioid litigation that we're engaging in on a national level. It covers the efforts that we take in the state to try to hold robocallers accountable and track those activities. I'm sure you might get many calls from constituents about calls they're getting. That information comes into us, and we work with our federal partners to work to track that, to try to stop that. We have a mediation service that's run out of our Consumer Protection Division. Typical case might be if one of your constituents buys a car, turns out to be a lemon, that constituent is having a hard time getting the dealer to pay attention to the fact that there may be a problem. We have a free mediation service that can help facilitate that conversation between the consumer and the business. Usually works out best for everybody because we have trained people who are able to help facilitate that dialogue. So the Consumer Protection Division really is probably one of the most impactful divisions in the office for individual citizens who are looking for some sort of information or support in dealing with an issue that they may need to deal with as a consumer. There's a criminal division in the office. This division, this is one of the places where I mentioned there's some exclusive work that the Attorney General's office is responsible for. So this office has the exclusive responsibility of investigating and prosecuting homicides. We have the exclusive responsibility of investigating and prosecuting political officials who are engaging in activity that is criminal in nature. We have exclusive responsibility over the use of deadly force, investigating and prosecuting the use of deadly force by law enforcement agencies. So we do have a division that has attorneys that deal with those crimes. We also deal with, we have a unit underneath the criminal division that's specifically focused on drug prosecutions, in particular drug trafficking. Most of the activity in that realm is on the trafficker side. There's, I believe it's 8 different drug task force team members who are located throughout the state, either in this office or are in with district attorneys' offices. We receive space from district attorneys' offices to have an AAG embedded right there, but they deal primarily with significant drug crimes. Additionally, this is also sort of stepping to the side. I believe District Attorney Maloney is going to be up pretty soon. She's the president of the Maine Prosecutor Association. She's the elected district attorney here in Kennebec County, also covers Somerset County. We work closely with the DAs. There's that shared jurisdiction, although the reality is that the DAs do a really good job at prosecuting much of the criminal activity that occurs in the state. So your thefts, your drug possessions, your robberies, your thefts of structures, stuff like that. Really where you see the Attorney General's office and the DAs working together is we're all in the Maine Prosecutors Association together. It's common that there's open dialogue between the Attorney General's office, criminal division, and the district attorney, the AAG, ADAs, about different work that they have, different things that are working, different things that are not working. So, I mean, really, it's a collaborative relationship. The only other thing worth mentioning, jumping ahead a little bit, is the budget for the assistant district attorneys and the DAs. The money is housed underneath the Office of the Attorney General budget umbrella, but that's really just a financial function. It doesn't equate to any level of supervision or oversight or what have you. So that's a quick look at the criminal division. We have a Health and Human Services division that's responsible for a lot. Its main client is the Department of Health and Human Services. And so it deals with advising on rulemaking for the department, representing the department in involuntary commitment hearings where you have an individual who is alleged to be a serious risk of harm to themselves or others. And so the state is seeking to have them hospitalized for treatment. We represent the department in those types of actions. We also see DHHS representing the agency in different litigation. There has been some litigation relating to COVID restrictions on restaurants, for example. This division has worked with the Department of Health and Human Services, the main CDC, in representing the state's interests in those types of cases. But it's a big, as folks here know, the Department of Health and Human Services is a large entity. So this division does cover quite a bit. We do have an investigative division in the office. These are sworn law enforcement officers who investigate those activities that I mentioned earlier. So, you know, they will be out on homicides. They will be out if you have this allegation of an elected political person who's engaging in certain types of criminal activity. They'll be out investigating if there's been a deadly use of force by a law enforcement official. They also are engaged pretty heavily in investigating financial crimes. That's a capacity that the legislature, in the last legislature, the 129th, recognized was important, provided some resources to allow for an investigator underneath that division. We appreciate that, and it's really going to help not only this office, you know, better focus in on prosecuting financial crimes, particularly for elder abuse related, but it also, I believe, will help improve the investigations across the state because this investigator is working with other departments on their investigations into that type of activity. We have a litigation division that is responsible for if the state is being sued by an individual or by a company or you know, by an actor. The litigation division is going to be involved in that representation, either at the district court level or superior court level here in the state, or on the federal. You know, we have a lot of federal cases that also in the Federal District Court of Maine, First Circuit Court. We do file briefs with the Supreme Court of the United States when necessary. Much of that comes from the litigation division. Additionally, there is some agency representation there. So, for example, the Assistant Attorney General that represents the Treasurer's Office is housed underneath the litigation division. It's you know, there's I think the saying is an ounce of prevention is worth a pound of cure. As the attorneys on this committee know, you do a lot of work at the front end to make sure that things are going right and that things are done right in the first place. And then you hope you don't have to, it turns into something else. So in the litigation division, we have those attorneys who are working with the state agencies at the front end to make sure things are going right. We have a division that's responsible for the professional and financial regulation. You know, there's different licensing boards that have been set up. We provide the legal advice for those boards. And if there's a licensing violation alleged, the AAG will serve as the I'm going to say prosecutor, but that's really not the right word to use. They will present the case to the board. There will be outside counsel who's available to help advise the board on their responsibilities during the hearing. But really, the AAG is responsible for presenting the evidence for the board to make its decision about whether or not there was a violation. Of course, the licensee may have their own representation. Finally, there's a natural resources division that's pretty self-explanatory, responsible for covering the agencies that like Department of Environmental Protection, Department of Marine Resources, that division is responsible for the environmental work that the state does, representing the agencies that do the environmental work. While I have presented these in a siloed way, what is really valuable is that all of these different divisions are available to help the other divisions. So for example, if there's a lawsuit that is brought against the Commissioner of Marine Resources, that may go to the Natural Resources Division because that's where the commissioner's primary representation is. But the litigation division that deals with a lot of the litigation in the courts is going to be available to support the Natural Resources Division. You may have a child protection case where there's a significant liberty interest that's been appealed to the Supreme Court here in Maine, and there's some questions about, what the right standard is, and what the right presentation, what the right perspective might be. The Child Protection Division is going to talk with the Litigation Division. So those are just two examples of how these different divisions do work with each other to get the work done. Also, I want to mention, and I recognize the time's running short here, there are other entities in the office that don't necessarily fit clearly into a division. We have a very robust civil rights team project. Not to draw too much attention to it, I know that Chairman Harnett had a lot of work with that project here in the office. He could probably do a lot better than I could at talking about just how valuable it is. But that project works with teams that are housed within high school, and we're now actually also engaged in middle level schools. It helps work to support these teams that become really grassroots, on the ground petri dishes for really important conversations about the civil rights that Maine protects, and all the important work we need to do to make sure that they're robustly upheld. So we have a project that's responsible for working with these and fostering these teams around the state. We are responsible for the victim compensations program. So the legislature has set up an account that allows for victims who maybe are not getting the restitution they deserve for medical bills or for some other types of loss because of a crime. There is some money that can be made available to these folks from a state account. We are where that program is housed, and we have people who run that program in our office. There was a major lawsuit back at the end of the 1990s, early 2000s around tobacco. We ensure that the state is doing what it needs to be doing through tobacco enforcement. That's housed here in the office. Recognizing now I have 3 minutes, let me just hit real quickly on a couple of other things. This office does engage in national work. So I frequently collaborate with attorneys general from around the nation in litigation that is important to the state of Maine and to Maine citizens. So for example, suing Purdue for their reckless and frankly, the lies that they perpetuated about how addictive OxyContin was, which led to a significant opioid crisis that is killing Mainers every day still, and has for years. I work with other states, other state AGs across the country to hold wrongdoers like that accountable. In supporting the Affordable Care Act and in ensuring that it's not stripped away, I've joined with other AGs, a bipartisan group, by the way, to defend that. So that's joining litigation, but there's also amicus briefs that I'll join. So I'll join with other states around the country, Republican and Democrat, to support or oppose litigation that's occurring in different places across the country. It's a way to ensure that Maine's voice is heard on how an activity, how a case should go. There's also significant consumer protection activity. So the opioid litigation is an example of that. Suing pharmaceutical companies for their practices. That helps not only hold different entities accountable, but it does bring in money to Maine that ends up benefiting Mainers, and we do see money going to different places to support where there may have been some problems.
Attorney General, I am so sorry to interrupt you because you're giving us a lot of really great information. I wanted to ask if you could just complete your presentation in respect of other folks' time available. And then also you have the department's legislative liaison here, and was hoping that maybe he would introduce himself as well.
Yes, so I can quickly say that the only other thing worth mentioning is that the AG's office does either facilitate or sit on a number of panels. So we facilitate the Deadly Force Review Panel that looks at deadly force by law enforcement. That's a new panel that this committee worked really hard to establish in the 129th. Sit on the Baxter Park Authority. We sit on the Maine Commission for Domestic and Sexual Abuse. We sit on different commissions, so the Attorney General's voice is heard there. And just finally, we do have a great team here in the office. We have really high caliber attorneys who do great work for the citizens of Maine and its agencies on a daily basis. One of those folks is Mark Mallon. He is the person that will help ensure that you can be in touch with me when you have questions or issues. And Mark should be on.
He is.
If you can,
would you like to introduce yourself?
Hi, everybody. Mark Mallon. I'm the Legislative and Press Liaison in the Attorney General's office. I live in Biddeford, although not in Representative Sheehan's district. And my email address is on the handout. You can feel free to get in touch with me anytime with anything you might need to communicate with our office on.
And many of you have my cell phone number already. If you don't, please have Soupy reach out to me and I'll make sure you get it, because I welcome if you call or text. I'm just not going to give it to the 14 people who are watching right now on the YouTube channel.
Thank you very much, Attorney General Fry. And I will just attest to your being available and helpful to me during the 129th on various pieces of legislation. Thank you and your staff for being available. I think at this point we are moving on to the Maine Prosecutors Association. But before we do that, we have two members of the committee who just joined us, Representatives Reckitt and Newell, and I would ask that you to introduce yourselves as well.
Good afternoon, Representative Rena Newell from the Passamaquoddy tribe. I did jump on probably about 15 minutes ago, so I was able to hear some of the presentation by our AG.
Thank you. And Representative Reckitt? Oh, I think you're on mute.
Anyway, I'm Representative Reckitt from District 31 in South Portland, and I've been on for the whole AG presentation. I just missed the Chief Justice. That's all. Or sorry, the acting Chief Justice. And happy to see you again, Aaron. Thanks.
Thank you both. And then I see that Megan Maloney is on with us today, and I will just turn it over to you, Megan. And if you've got, I see that District Attorney Sarbeck is also here. If you could all introduce yourselves and provide us with your presentation. Thank you.
Thank you. Thank you, Senator Carney, Representative Harnett, and honorable members of the Judiciary Committee. My name is Megan Maloney. I'm the District Attorney for Kennebec and Somerset County, and I'm the President of the Maine Prosecutors Association. And I'll let Jonathan introduce himself.
Hello, everybody. I'm Jonathan Sarbeck. I'm the District Attorney here in Cumberland County, which is prosecutorial on District number 2.
So what we've provided you with already is an overview of the criminal justice system that I'm guessing you received via email. It's dated January 21st, 2021. If you have any questions, we're happy to answer them at any time. You can contact me via email. I'm happy to give you my cell phone number. So we can absolutely be available for any time you have questions. But what we thought we would do today is really hit on some of the big issues that we are that we're working with in the work that we do, instead of the day-to-day nitty-gritty. So the day-to-day is covered in this document, and we have a PowerPoint presentation, and that kind of focuses more on the cutting edge issues and some of the things that we think might come before you in this legislative session. So I'm going to see if I can share my screen. I have, if not, I've sent this to Peggy just in case. Let me see.
There we go.
Did that work? Yeah?
You
Oh,
see
great.
it?
Okay. So these are the conclusions and recommendations of an extensive audit that our adult treatment courts throughout the state of Maine has just gone through. So these are slides that were put together by, let me see, there we go, by Helene Hornby as the principal investigator. She's a third party. She has no connection to our courts, to our justice system at all. Her job was to come in and find out, how are we doing? and her findings are so remarkable that it's really our goal to just make sure as many people know about this as possible. She is happy to come and do a real deep dive into her findings if you'd like to hear from her. She has far more slides than what I included here. I have to, because I know I have to keep it brief. So going into this, her conclusion, most important, is treatment courts enhance public safety and improve lives at no additional cost to taxpayers. Now, I know I've said that before, and I had some data to back it up. This data is so much better than anything I've ever had access to before, and I love that this conclusion is not by a player in our system, but is by someone from the outside looking at what we're doing. So she looked at 4 things: reduced recidivism, fewer mortalities, testimony from the participants, and cost-benefit analysis. So going quickly through this, these are the groups of people that she looked at in the treatment court. You can see the different types of crimes that they were charged with. And then you can see the comparison group and the different types of crimes that they were charged with. And so this is just to show you that the treatment court participants and her comparison group were charged with very similar types of crime. So she's not looking at apples and oranges. She's really looking at apples and apples. So they're very, very similar. These are the ages of those in our treatment court in general. And this is where we get very interesting information: the arrest recidivism rate. So the treatment court versus the comparison group. The treatment court at 18 months is what she identified as her best data, because that was her largest group. So every time she talked to us, she would focus our attention on the 18-month column. And there you can see it's a gigantic difference. Those who were able to be in the treatment group were arrested, 20% of them after the treatment program ended. And the group that did not go into the treatment court, 47% were arrested. The conviction rate, another similar statistically significant difference of 15% for those in the treatment court and 40% for those who went the traditional route. And again, this is 18 months after they complete everything that they had to complete. So for the treatment court, it would be 18 months after they graduate. For the comparison group, 18 months after they finish prison or finish probation, whatever the comparison group was required to do. This is the slide I like the best, and it's because it looks at the graduated group. And again, if we look at the 18-month, those who graduated, their conviction rate is at, I think that's 13%. I need to get the numbers bigger, 13%. But those who didn't graduate, who entered the treatment court but did not successfully complete the program. They still have a recidivism rate of 18% instead of 40% of the people who were not in the treatment court. And that I did not know. I never knew this information, that even the people who don't successfully graduate from our treatment court program, even that group is not impacting our community with new crime at the rate of people who don't receive any treatment court at all. So that was very, very exciting news. I had no idea. And again, this is looking at the conviction rate for those who leave prison after 18 months. 58% of them are convicted of a new crime. After jail, it's 43%. After probation, 20%. So showing again the different recidivism. Mortality, it's similar. The mortality rate for the comparison group and the treatment group. Treatment group is lower, but not significantly, statistically significant, but still lower. So that was still good news. And then the participant testimony is, I'll just read you the first one. I gave up on myself, but they, the treatment team, did not give up on me. And this is something I hear again and again from our participants. For some of them, it's the very first time in their entire life that they've been told that they have a purpose, they have a reason for being, that we want them to be a part of our community, and that they can do something good with their life. There are many people who grew up their whole life never hearing that. And it's heartbreaking, but once they hear it, it completely changes their whole way of viewing the world. And cost effectiveness, I know Jonathan wanted to talk about the cost effectiveness.
Yeah, so thanks, Megan. One of the things I think is just very important about this as well is that people really kind of have to have an understanding about the cost of jail and the costs that go along with actually incarcerating somebody. And we know what they are, and we take that step reluctantly if we have to, but if public safety deems it necessary, then as prosecutors, we have an oath and we go forward with that process. But what these treatment courts do, and I think that this slide really kind of makes that point quite known, is it actually costs less to have someone go through one of these treatment courts compared to what it costs to put somebody in jail and incarcerate that person. And to me, the benefits of these treatment courts really kind of will have a lot longer lasting effect in a positive way for somebody who then gets out of the treatment court, as opposed to just simply getting out of being incarcerated. And so I think, to me, that there are two benefits. One is that we're going to leave a person in a situation that they're going to be much better off in their own recovery, and hopefully reducing that recidivism that they come back into the criminal justice system. And then the other is to average taxpayers, knowing that the money that usually goes into county budgets or budgets for DOC at the state level, we're going to actually reduce by using these treatment courts, as opposed to having to incarcerate these individuals.
And something to explain about this slide as well, the jail, prison, and probation number under treatment, the treatment courts do not have upfront jail or prison time. That is representing the jail and prison that is used by the treatment courts if someone's not successful. So she included even that number in this analysis to make sure that it was completely unbiased and that every single cost was factored in. And even including that number of the people who don't graduate and the cost of housing them in an institutional setting, it's still lower than the amount of money spent on treatment is still lower than the comparison group, where a person spends their time directly in jail and probation or prison and probation. So that was that was also key. I know I've been asked that question many times. Well, what about the people who aren't successful? Doesn't that bring up the cost? It does. It does significantly, as you can see. It's a significant cost increase. So the more we can be successful, the more we'll keep the costs down. But even considering that, it's still less of a cost than what we think of as a traditional criminal justice system. So that was nice to see.
Can you please read out those numbers? Again, they're a little tiny on the screen, and it would be nice for us to all hear them. Thank you.
Absolutely. So these slides I provided to Peggy so she can absolutely share it with you. It is all public. And as I said, there are even more slides that I didn't include because of time limitations. So if you want to have the whole deep dive, we can provide that to you as well. But under treatment, the cost of case management, treatment, and judicial for one person to go through our court is $10,964 a year. And the average cost of the number of people in our court who are in jail, prison, or probation, what that cost is $27,229. If you add up those two numbers, it comes to about $38,000. And the comparison group is $43,461. So the comparison group is about 13,000 more than the treatment group. And that is also something that I know Helene could explain even much better than I can. I listened to her presentation on this 2 weeks ago. I mean, this is very new, very fresh information. And so she could explain exactly how she dived in to pull those figures if the group would like that.
Thanks.
She had a lot of things to work on that we need to work on. And I provided all of those to you because this is something that, again, you might want to take a look at the slide deck and pull out whatever is of interest to you. I'm going to focus on the two slides that directly impact prosecutors, that talk about the work that we do, so we can answer those questions. So the first one is slide 20. Number 5, create new adult treatment courts in judicial regions 6 and 8. This is an important one because we do have 2 districts in our state without an adult treatment court. And seeing how well they work, that's really a tragedy. So that's an important recommendation. We fully support having that expansion. And I know that the district attorneys would certainly be receptive to that as well. And then slide 22.9, enhance the availability of prosecutorial or assistant district attorney or assistant attorney general time. And what that is referring to is that the courts do work best when one prosecutor is assigned to the court as the point person for the court to be able to answer all questions and do whatever needs to happen for that court. The difficulty here is, for example, with the Veterans Court and the Co-occurring Disorders Court in Kennebec County, I have a prosecutor who handles that docket, who is working up to 75 cases at a time. So 75 people in the court at a time. In comparison, the people who are handling things in the traditional way, which I hope someday that changes, but the standard way, can handle, they currently have up close to 500 active cases. So if you look at 75 active cases versus 500 active cases, that's the difficulty of committing prosecutorial resources. I know that in order to get a treatment court in Somerset County in my district, I am the attorney who handles all of the cases for that court. And I know that Jonathan has stepped up to handle the cases for the treatment court in his district. And that is a key piece that's necessary for these courts to work well.
And one thing too on Megan, we also in Cumberland County, I'm not sure how other districts do it, but our diversion coordinator, who's not an attorney, but she's one of our staff, she puts a tremendous amount of work into the drug court with looking for referrals, communicating with defense counsel and prosecutors. If somebody is made as a referral, putting together the summary sheets each week for the session, which basically tells the judge and the court and the team about how that person's doing, if they're having any issues, if they've had any positives, and really kind of keeping a history of that person's progress as they go through the weekly or the every 2 weeks drug court session. And so without her, and I have to give her kudos because she, like I said, puts a tremendous amount of work in, our drug court would not work as efficiently.
Yeah, it does take a lot of people, but remember when people go through these treatment courts, they are living in our community. And that is a big piece of what keeps the costs so low. And these costs also don't factor in that the team works with the person to pull all the pieces of their life together. And that includes getting a job, getting housing. And so they're contributing to our community in that way as well while they're in the court. So that's another, and that piece of contributing wasn't even in the cost calculation. But not putting someone in an institutional setting, but instead having that person live in the community really keeps the cost down low, even though it does take extra case management, as Jonathan was talking about, and extra prosecutorial resources, extra judicial resources. But still, an institutional setting is just extremely, extremely expensive. So then going ahead, one of the things that you did hear, Jonathan referred to his court as a drug court, and I referred to mine as a co-occurring disorders court. One of the other recommendations is that all of the courts become ones that focus on both substance use disorder and mental health. And that's another big push that we're undertaking right now, is to try and get that mental health component for all the treatment courts. And if you look at how successful they are now, even without all of them having that, there's no question it would just increase the success. So, and then looking at other alternatives, Jonathan was going to talk about some of these.
Sure. So one of the big things we wanted to just discuss, and I am aware of the time, and we do want to leave a couple or a few minutes for some questions if people have them. The mental health docket is a docket that was actually born out of necessity in Cumberland County, because we had so many people who were coming into the criminal justice system who had mental health issues that really made it so that they actually weren't able to participate in the legal process. And what would happen was that a state forensic would be requested to make a competency evaluation on that person. And while they were waiting for that competency evaluation, they would basically be at the jail. And as any sheriff across the state will tell you, and as many of us all agree, that the jail is not the right place for someone to get treatment with regards to a mental health issue or a substance use disorder issue. And so what we did is that we would start kind of streamlining these cases on a court docket that met every week or every 2 weeks. First it was every 2 weeks, now it's every week in Cumberland County. And we would really kind of streamline those cases to make sure that they were getting the attention that was necessary. So if the evaluation wasn't done, why wasn't it done? Let's get this done. And then once it was done, all right, we're going to review this and see where it goes from here for that person to either get a bed up at Riverview or up at Dorothy Dix Hospital. And it really has worked very well in Cumberland County. And I think Megan has a docket up in Kennebec County as well that it works very well up there. But the idea is to make sure that these individuals aren't just sitting at the jail where we know is not going to be the best place for them. And so we've been urging for other counties and other prosecutorial districts to have this docket as part of just the regular business of the court. It does take staffing by the DA's office. So there is an ask for resources from the DAs, and it's one of the important things that we want to make sure that you all know that creating dockets does require resources from the court, from defense counsel, and definitely from prosecutors. The other thing that we've been doing is we are trying to have diversionary programs that doesn't just divert somebody from having a criminal record, but somehow can divert people from actually coming into the criminal justice system. We've been using in Cumberland County and Androscoggin and Kennebec, we've been using restorative justice, which is a pre-arraignment, or some of the systems are pre-arraignment or either post-arraignment, but before the dispositional conferences that allow a dialogue that an individual can have with a representative from somebody who's practiced in doing restorative justice, and then a community surrogate, or if the case involves a victim, having the victim involved. But basically, the idea is for an individual to be held accountable, but then really have an understanding about the harm that they've done, with the idea that one, the victim is going to be more satisfied about the process, but another, that a defendant's going to understand the harm and the harm that was caused by the actions that he or she took. And we've got some, and then what happens if somebody then goes through that restorative justice process, the case is dismissed. That's the nice thing about being a prosecutor. It's a very powerful tool that we have, and we obviously have to use it with a lot of responsibility, but is that we can just file a dismissal with the court and the case is gone. So we can actually not have to go into a court setting and not use those judicial resources if somebody goes through this process and we think actually gets more out of it than going through a criminal justice system where they might just end up with a fine. So we've been using that, the restorative justice, the crisis and counseling in Kennebec, the Penobscot Bay at the barn, the bad check program, the shoplifters alternative program. Community service is something that we've been using for a long time. With the pandemic, it's a little bit limited with what you can do with community service. And then obviously with substance use disorder treatment, if we always tell defense counsel, if you can provide us with information about what your client has done to address the issues that he or she has that brought them into the criminal justice system, we will take that into consideration if we can. And so those are just some of the diversionary tactics that we're using. We're still using deferred dispositions quite a bit with making sure that somebody is actually going to take responsibility by pleading guilty, but then we give them an opportunity to go through that probationary period with the hope that the case is either the plea is withdrawn and the case is dismissed, or it's reduced down from maybe a felony charge to a misdemeanor charge, so that person can avoid having that felony record. But Megan, anything else? We left 3 minutes for questions.
Right. So we have some, I did provide you with a document on some of the things we've been talking about in relation to the pandemic. And so I just wanted to mention that. One of the big things that I know that I keep hearing that's missing is a safe place for juveniles to live in the community. Juveniles who don't have, who can't live at home. Foster care isn't really available to them. And that's definitely a problem that we face. So this is the conclusion.
Yeah, one more thing. I did just want to put out that we are the district attorneys, whoever is in your district, we are available to answer any questions that you have with upcoming legislation, to know what practical effects might be out there. We will most likely be taking positions on the legislation that you see in front of you. But if people do have questions about, okay, if this law gets changed or we institute this new program, how is that going to affect the prosecutors in the courts across Maine? We'd be happy to answer those questions for you.
And I put our phone numbers up on the last slide, as well as our emails, so that you'll know how to reach us. We're happy to answer questions. And we can take questions now, but I know that there's not a lot of time remaining.
Still muted. Okay, there we go. Thank you both for that presentation and for sharing with us a lot of information that's pretty impressive about the work you've been doing. I see that Representative Harnett has a hand raised, so I'm going to call on him, and that may be the only question we have time for. Go ahead.
Thank you. It's a question, but I also just want to share with the committee. I know that there are a lot of questions that these presentations raise, and this was designed to be an introductory overview, particularly for newer members to the committee. Just like Chief Justice Mead stated that he would make himself available, I want you to know that Senator Carney and I will request that all of our presenters today make themselves available so that we can have more in-depth questioning. This is a lot of material to digest, and a lot of people might not even have their questions formulated until they process it, although I know there are some members that do have questions. But my quick question is, I've been reading a lot in the paper about the problem with the pandemic and the delay in criminal trials is we have people sitting in county jails unable to make bail. Now, these defendants are presumed innocent until their guilt is proven, and their inability to make bail, coupled with the inability to have a trial, often leads them to lose their home, lose their job, lose their standing in the community. What steps, if any, are the DAs taking to address that problem right now? And
that is an
recognizing the constitutional rights of the defendants.
Yep, that is an excellent question. Excellent question. So the ACLU reached out to me at the beginning of December, around maybe end of November, with the same question. And I spoke with Attorney Hayden, and what we came up with on our conversation is to really look at everyone who's accused of a Class E, D, C, or nonviolent felony, and to see if we can get all of those people out of jail, and to make sure that the only people left in jail are people who, if we had a dangerousness assessment in Maine, which we don't have, they would be found dangerous by the court, and that's why they have high bail, because we can't use a dangerousness assessment. So I did that in my district, and I know that several district attorneys also did, because I sent this out via an email and they all responded back. And so as of the end of the year, there was no one left in Kennebec or Somerset County who was there on, and so I'll say it again, a non-violent felony or a Class E, D, or C crime. We were able to reduce the bail or settle the case, do something to move all of those cases to a place where people weren't just in jail on bail awaiting trial. There are always going to be cases where it's simply going to be my argument that they're too dangerous to be released before trial. And with those, it is up to the court to make that ultimate determination. And the court makes that decision by holding a high bail. So I don't know if Jonathan, if you wanted to add.
Yeah, no. So when the pandemic hit, that was a concern that all of us shared about not just what's going to happen at the jail, but we actually reviewed, I think, every inmate that was over at the jail and see if we could come up with an agreement on reducing the cash bail or creating conditions that we felt weren't going to compromise public safety, but at the same time not violate someone's due process, especially back in the early days of this, because due process was at a standstill. The court was at a standstill. And I think we reduced at least Cumberland County, we reduced the jail population by about 35%. And that's how we've been approaching a lot of these cases when they do come in, on how we can basically get somebody out of jail, but at the same time not compromise public safety or the integrity of the court of that person coming in. I think we've done a good job with those numbers. At last check, I think 2/3 of the people who were being held pretrial at the Cumberland County Jail had multiple dockets, meaning that there were multiple cases. Either somebody was arrested and or released and then arrested again. or that there were cases that they were over $1,000 cash bail. $1,000 is no magic number on that, but that's just a threshold that I'll ask the jail for those cases to review and to look at, okay, why is this person on cash bail? And the whole method behind that is to, if there is somebody that there's $300 cash bail, but they've been there for 10 days, all right, that could be problematic. And I'm going to have reach out to the prosecutor and say, hey, can you check into this? We might need to amend this bail to personal recognizance, especially if the person's been in jail for 10 days and it's a case that we might plead out for 4 days or something along those lines. So that person should get personal recognizance bail. So I believe we are being proactive to review those cases, but at the same time, realizing what our role is in the criminal justice system and to make sure that public safety isn't compromised.
And thank you, and I'm very cognizant of time, but one of the things, thank you for giving us the PowerPoint presentation and making it available, but you jumped through a couple of slides towards the end, and I was having trouble reading the font, but I did see something about racial disparities, and we didn't talk about that. I'd really like to talk about that, what that was about the next time that we have you before us. Thank you, Madam Chair.
And what we found is that there is a difference in the number of people in the treatment court. There's a racial disparity for the number of people in the treatment court compared to the number of people who are the racial makeup of people accused of a crime. And so we need to figure out why, and we need to address that. And so that's an important point. Jonathan actually was one of the people who spearheaded bringing an implicit bias training to all the prosecutors throughout the state. And we just completed that 6 days of training, 2 hours each day, homework in between. And we are actively working to address and make sure that we are not being influenced by either overt bias or implicit bias.
Thank you. And I know the chair wants to move on, so I'm sure we'll have questions about the next time that we speak. Thank you, Senator.
Thanks, everyone.
Yeah, and just to echo what Representative Harnett said, thank you very much for your presentation, and we will be back to you with requests for information. And if you could please provide the slides so that we can distribute them among the committee members, that'd be helpful.
I did provide it to Peggy.
Wonderful, thank you. Okay, so we have one more presentation before we take a little break. And I appreciate everybody hanging in there. This is a lot of information that we're all absorbing this afternoon. But our final presentation before the break is the Maine Commission on Indigent Legal Services. We have Josh Tardy and Justin Andrus, and they are both here today. And I think that Ellie Maciag also plays a role in the Indigent Legal Services. So welcome today, and I will turn it over to you. If there's anybody else on your team who is participating today, please introduce yourselves.
I think you have everybody, Madam Chair, and thank you. If everyone can hear me, Senator Carney, Representative Harnett, and distinguished committee members, I'm Joshua Tardy. I'm a resident of Newport, Maine, and I serve as chair of the Maine Commission on Indigent Legal Services. The memorandum that is part of the packet from us, Maine Commission on Indigent Legal Services, sets forth who we are. We're an independent commission created by the legislature, and our purpose is to provide quality representation to criminal defendants, juvenile defendants, and children and parents in child protective cases. As a commission, we are required to oversee a system that provides efficient, transparent, and accountable legal services to indigent persons. And as you are no doubt aware, the Commission's performance has been closely scrutinized even since the newly constituted Commission began work in summer of 2019. And the new Commission with the newly appointed commissioners have been meeting on a very regular basis and are very passionate about improving the public's confidence in our mission, in our performance, and our delivery of services. Madam Chair, our memo that staff put together for your committee's banks to this, that put mission in our system under a microscope, and that's there for your conveniences. And we're certainly happy, as Representative Harnett suggested, to come back in front of you. We expect a very engaged dialogue with the Judiciary Committee over the course of this legislative session. But
I'm sorry to interrupt, Mr. Tardy, but I think that your reception might be, I don't know if others are having difficulty hearing, but could you just back up about 4 sentences for us? Your voice completely blurred out. Thank you. And if you are having connectivity problems and you need to turn off your video in order for the audio to come clear, that's fine with us as well.
That might make sense, and I wouldn't mind that. So hold on, if I may. Madam Chair, are you able to hear me now?
Yes, please continue.
Okay, I don't really have it scripted, so I'm not sure where I went off audio, but I wanted to let you know, and the committee members know, that the reports which have scrutinized performance of the delivery of legal services, we have provided links as part of our memorandum that are in your packets, and as a convenience for your members. So that, for example, the working group's report from 2017, the Sixth Amendment Center report, the most recent OPEGA report, and those are all part of major investment in human resources to study and analyze the delivery system's performances over the past decade. And so those are there for your convenience. Under separate cover, we will also transmit to you as a committee our annual report that is required by the legislature. But as the memo indicates, the commission has made some significant progress over the past 18 months, and we're very pleased to onboard Justin Andrus, who has accepted the role of interim director. We appreciate that Justin was able to be recruited, that he is stepping into this very important transitional role, and we thank him for his commitment to public service. We understand that we have a budget request that reflects the recommendations of the Sixth Amendment Center report, and we understand that that will be part of a very ongoing dialogue and exchange of ideas and debates with the legislative branch, and we look forward to that discussion. One of our proposals in our biennial budget request to the chief executive calls for the implementation of a public defender office specific to Kennebec County. It also calls for the appellate defender office. We understand that those come with a price tag. We have a series of recommendations that have budget impacts, but we know, and I'll certainly turn it over to questions. We know that the commission recognizes that we have a system that needs to improve. We recognize that we are vulnerable as we presently stand to a constitutional challenge. And we recognize that any commission or agency that comes forward and asks for money, and in particular, in this case, more money, that we can't do it credibly unless it's accompanied by a demonstrable change and a commitment thereto. And so we do, however, strongly believe that under the present system, that a vast majority of our rostered attorneys are committed, competent, dedicated public servants who do great work. And we do agree that alternative models of the delivery of the system need to be explored. And that's why in our proposal to the chief executive, we have called for, I call it a pilot as it relates to a public defender project. And we further are looking at expanding the public defender model to the appellate practice. And so at this time, I'd certainly like to introduce to the committee Justin Andrus and Ellie Maciag, who are staff employees for the Maine Commission on Indigent Legal Services. And I'd ask if Justin would like to, briefly address the committee, and then I am sure that there will be a bunch of questions, Madam Chair.
Yeah, that's a fine way to proceed.
Good afternoon. I'm Justin Andrus, and it's my third day at MCILS. But I've been an MCILS rostered attorney since the entity has existed, with the exception of last year when I served for a year as assistant bar counsel for the Board of Overseers. And so I come to this with a lot of experience in the system, a love for the need to provide excellent service to the indigent people who need it, and also an appreciation for needing to do that within the framework that's available to us. It's going to be challenging, exciting to have the opportunity to do it, and here I am. So rather than guess what you might want to know, I'm happy to answer questions as best I can. Ellie is on the call, and I don't know if she wants to step in also, but I do want to recognize loudly and publicly and every chance I get that for quite a long time, she's been the glue that's been making this place work. She's working really, really hard, really, really long hours, and all of us who rely on MCILS to fulfill the state's constitutional obligation should appreciate her for that.
Ms. Maciag, would you like to introduce yourself and greet everyone?
Sure. My name is Ellie Maciag. I'm the Deputy Director of MCILS, and I've been on the job since 2012. And I'm very excited that Justin is on board.
Thank you very much. Okay, so at this point, we've got a full 15 minutes, which is great. It's more question and answer time than we've had with our other presenters. I know that some of the information that we will be seeking out in connection with budget and potential legislation will have other opportunities to ask questions, but let's just have folks raise a hand, and I will recognize members of the committee for questions. Senator Keim?
Madam Chair, I do recognize that we'll have opportunity to just dive into some issues later on. Ellie, I do want to kind of go on what Justin said, and thank you for the work that you've done. I know this transition period has been really difficult, and you've just stuck through it, and I am very grateful. On the behalf of Maine people, I'm very grateful. And Justin, welcome. What I would love to hear from you is just any of your first insights, but maybe it's too quick for that. So definitely love to have some of your insights as soon as you feel that you're able to offer them to us. That would be great. And then my question is just that Josh mentioned a pilot program, and one of the concerns that was raised when we discussed this before about having a pilot program is how do you convince people to give up their practice with what seems like a short-term commitment, you know, on the state's part to them, and yet maybe long-term commitment for them to be giving up their clients and all that. So I just wanted to hear if that was much of a discussion, and of course I assume it would turn into something permanent, but on the other end, if I was the one asked to give up my practice to jump onto something that's termed temporary, I would be reticent.
Yeah, Madam Chair, if I may answer Senator Keim's question. So with respect to the concept of a pilot, that's pilot is a word that I've used and is probably not accurate. By design, our budget proposal would be to create a permanent defender model in Kennebec County, and then basically looking at how that played out to see if it warranted expansion to a statewide or an additional geographic area.
Thank you. Senator Keim, did you have other questions?
The one follow-up I would have to that is, and I being conscious of other questions that people might have, possibly it's something that could just be filled in later, but why Kennebec as opposed to Cumberland? And again, I think that's probably something we could get into later if someone would just make note of that.
Certainly.
All right, are there other questions from committee members? Representative Harnett.
Thank you, Madam Chair. This is for anybody who wants to answer it. One of Maine is the only state without a public defender office. And one of the reasons that we hear is because Maine is a very rural state with some parts of our state being very lightly populated, and it's hard to set up a public defender's office under that scenario. But we're not the only rural state in the country. And in fact, there are many states that are far more rural than us. I'm curious as to what you think, why do you think they're able to establish a public defender's office, but we almost don't put it on the table?
Mr. Chair, thank you. Josh Tardy again. Well, first, those states have made the decision legislatively and from the chief executives to fund it. And I would say that even rural states that have implemented public defender's office usually do it in coordination with an assigned counsel system. And so there are hybrid models that can work. And we have a subcommittee that's tasked with analyzing what models would work and how that would impact assigned counsels and those private attorneys who take conflict-related cases.
And I would imagine part of the reason for that is you don't want to lose that body of knowledge that's out there with the assigned attorneys. That, as you've stated, the vast majority are competent and very effective at what they do.
And I think Senator Kime made a good point. As far as there's a risk that if you discourage them taking assignments without a system adequately implemented, we do more harm than good at times.
Thank you.
I see that Representative Babbage has his hand raised, but before we get to you, we've been joined by another committee member, Representative David Hagan. Representative Hagan, would you like to introduce yourself to the committee? Oh, you're muted.
Thank you, Madam Chair. I appreciate it. I am David Hagan. I am in a science classroom as we speak. Our school day just ended, so apologies for being a little late. And I'm very interested to hear everything that's going on.
Could you please let us know
what
your district?
Yep.
Great.
I represent House District 101, Hamden and Newburgh.
Thank you and welcome. All right, Representative Babbage and then Representative Evangelos.
Okay, thank you very much, Madam Chair. Yes. Good to see Representative Hagan again. Yes, my question is directed to Justin. Maine's unique situation, I thought presented the problem of an uncontrolled budgetary matter in the way that we pursue justice here with our constitutional obligation. And at the same time, its strength was an uncontrolled budgetary matter. I mean, the idea of going to a public defender system or any contractual system, I thought, lent the potential problem of rationed justice. And I guess what I would ask Justin is where we rostered, and this could be with a public defender system or our prior system, but was our constitutional obligation met with a varied performance county to county in your understanding or not? Thanks.
So there were certain, may I proceed, Madam Chair?
Yes. Oh, I'm sorry.
Yes, go ahead.
Thank you. So there are certainly differences culturally in the practice from county to county. I was rostered primarily on the mid-coast. My practice before I closed it to join the Board of Overseers and serve there for a little while. Had 3 offices in Portland, Brunswick, and Camden, and most of my work personally was between Brunswick and Camden. And I had folks at each end. And so I did practice more statewide than that in certain specific areas. For example, I did post-conviction review, and that post-conviction review practice was statewide. I'm not sure I was literally in every county doing that, but I was in most of them at some point doing that work. And in doing post-conviction review, I got a really good insight into how people were performing, both at an individual level and what the expectations were in those counties. And so maybe that's detail on that's probably a longer conversation for another day that I'd be happy to have with you and with anybody else here today who'd like to have that conversation. It was not my observation that there was an epidemic of subconstitutional performance. There were instances on post-conviction review. There were instances in cases I was involved in when I used to do grievance defense. There were, without any detail, instances I saw in my last employment, and I'm already aware of instances here. We need to address that. It's a small fraction. Generally speaking, we are meeting our obligations, which is, I think what your question was primarily.
Do you have any follow-up, Representative Babbage, or are you all set?
No, in this forum, I wanted to approach it generally, and I thank you for that, Justin. Appreciate it.
Yeah, and you're correct to observe that we'll have other opportunities to ask more in-depth questions. Representative Evangelos, you have the floor.
Thank you, Madam Chair. I did want to answer Representative Harnett's question. Having studied the civil rights movement and other related things since the 1960s, we're coming to the tragic understanding that we're learning in the Judiciary Committee that one of the deficiencies we're dealing with in Maine is that the truth is we're dealing with a marginalized and stigmatized class of people, poor people and African-American people who have committed a crime, and we're not willing to invest money. $60 an hour is so inadequate. And we've had this discussion with Josh, because I do attend some of the commission's hearings, but a plumber in Maine is making $70 an hour right now. I'm not putting down the profession, but I'm just making a point that they didn't go to law school, and certainly the charge they're charged with trying to defend a poor person. With the deficiencies outlined in the Sixth Amendment Center, our situation is tragic, really. For these folks to be going to court, lacking continuity of counsel, you get a different lawyer of the day every day, unfamiliar with the circumstances that happened the previous day. So I know Representative Harnett.
Did you have a question, Representative Evangelos, for any of the three?
No, you said that we could answer Tom's question, I believe. Tom posed a problem. I was wondering, and I'm responding to it.
I don't recall this being an opportunity to answer other committee members' questions, but why don't you just summarize and continue briefly, because
I was done. I just summarized.
Oh, okay, great. Thank you very much. Other committee members have questions in the last 2 minutes for the members of the Indigent Legal Services Commission who are here today? All right, I'm not seeing any hands. We are going to take a 15-minute break. Oh, Mr. Andrus, did you have a final remark you'd like to make?
Oh, thank you. No, I scratched my face.
Okay. Well, thank you very much for being here. We are going to take a 15-minute break, and I would just ask all members of the committee to be aware that we'll continue to be streamed on YouTube. So please turn off your cameras and mute while we're on the break, and then we'll start back up at 2:45. Thank you, everybody.
Hello. Shut it.
Hi, everyone who's on. We are going to get started in just a couple of minutes. We're just waiting for some committee members to return to the meeting after a much needed and well-deserved break. So we'll get started in just a moment. All right, it looks like just about everybody is back. I'll just review the rest of our presenters for this afternoon. We've got the Maine Human Rights Commission, Pine Tree Legal Assistance, and the Maine Indian Tribal State Commission. And I will introduce the Maine Human Rights Commission. We have here the Executive Director, Amy Sneerson, and Barbara Archer Hirsch, who is the Commission's counsel. And would you like us to go over, since you weren't on for this morning, would you like committee members to introduce ourselves, or would you like to dive into your half-hour presentation?
It would be great to know. There are some people that we haven't met here before, so it would be great to know who everybody is.
Great. I am going to, because we can't just look around the horseshoe, I'm just going to call on people and ask them to introduce themselves. I will start. I'm Ann Carney. You both know me. I am a state senator for Senate District 29. I used to practice before the commission, which is why we know each other. I'm just going to go around my screen. Representative Babbage.
Yes, hello. Good afternoon. My name is Chris Babbage. I represent House District 8, which is most of the town of Kennebunk.
Senator Keim.
Good afternoon, Lisa Keim. I represent Senate District 18, which is much of northern Oxford County and two communities in Androscoggin. And just so you know, my internet connection seems a bit unstable. So if I have to turn off my video, that's why. It's just to keep you all from freezing. Thank you.
Representative Newell.
Yes, good afternoon. My name is Rena Newell, and I am the Passamaquoddy Tribal Representative.
Thank you. Representative Sheehan.
Thank you, Senator. My name is Erin Sheehan, and I represent House District 12. That is downtown Biddeford. Good to meet y'all.
You too.
Representative Downs.
Yes, good afternoon. I'm Kathy Downs, and I represent District 130, which is Bucksport and Arlington, and this is my first term.
Thanks. Representative Moriarty.
I think you're muted, unfortunately.
Welcome to the second half. I'm Steve Moriarty, State Rep from District 45, which is Cumberland and the southern part of Gray.
Thank you. And Representative Reckett.
Hi, I'm Lois Reckett, and I represent the District 31, which is the ocean end of South Portland.
Thanks. Representative Harnett.
Thank you, Madam Chair. Nice to see you both again. My name is Tom Harnett. I represent House District 83, which is the town of Farmingdale and the city of Gardner. And this is my second go round on the Judiciary Committee, and I'm serving as House Chair.
Thanks. Representative Poirier. Poirier.
Poirier.
I'm working on it. I promise.
That's okay. My name is Jennifer Poirier. I'm serving my first term in the House, and I'm representing District 107, which is all of Skowhegan and a little piece of Madison.
Thank you. Senator Sanborn?
Thank you, Senator Carney. Heather Sanborn. I represent Senate District 28, which is half of Portland and half of Westbrook. And it's my first turn on the Judiciary Committee, but I'm in my third term in the legislature.
Thank you. And Representative Hagan?
Thank you, Madam Chair. I am David Hagan. I represent House District 101, Hamden and Newburgh. This will be my second go around with Judiciary and third term.
Thank you very much. And now we will turn it over to the Human Rights Commission. Let us know, please, if you will be saving some time at the end for questions or how you'd like to handle that. And the floor is yours.
Thank you. So I'm Amy Sneerson, and my colleague Barbara Archerhirsch is here with us. I think there will be time at the end for questions, but if folks have one along the way, that's fine too. I'm going to attempt a screen share, and I'm not going to be as good at it as the district attorney was before me, but I'm going to give it a shot. Okay, let's see what happens. So this is intended to be not an overall picture, but just a surface view of what the commission is and does. And I'm mostly a word person, so this is mostly a bunch of words on slides. So sorry, it's not more visually interesting. So the commission, for those of you who have not served on judiciary, and as a refresher for those of you who have been here before, we are a quasi-independent civil legal enforcement agency. Our only job really is to enforce the Maine Human Rights Act. But we also are tasked by statute with enforcing the Maine Whistleblower Protection Act. And I'll talk in a minute about where that applies. This is the state anti-discrimination law, and that's the sole reason for our agency to exist. We have statutory mandates that include enforcing the law, but also there's wonderful broad language about preventing discrimination and addressing the right to a life with human dignity in the state of Maine. It also includes our statutory obligations include making recommendations for legislation or executive action concerning discrimination. And we will frequently be asked questions by legislators or other stakeholders and end up before the committee, which is our committee of reference to do that. Our statutory structure is that there are 5 commissioners appointed by a governor. They serve 5-year staggered terms. By statute, no more than 3 commissioners from any political party. We are apolitical, we are intended to be, and it actually operates that way. The commissioners in turn hire staff. They hire the commission counsel and the executive director, and I supervise all staff. The areas of jurisdiction that the statute covers. So the anti-discrimination law applies in employment, in housing, in public accommodations, which is essentially places and services that are open to the public. There's a lengthy and detailed definition of that in our statute. It mostly gives examples of what a public accommodation is. Incorporated within that definition is actually public entities that do not offer their services to the public. And I mention that only because there's, I believe, going to be a bill introduced related to that later in the session. The Maine Human Rights Act applies in education and credit extension, and minimally to offensive names and breastfeeding. There is also a standalone, that's about as exciting as my visuals get. There's a standalone prohibition that applies across all areas of jurisdiction that says it's unlawful for any person to retaliate against or interfere with someone else's assertion of Maine Human Rights Act rights. So there's a lot of ways in which the Maine Human Rights Act is broader than the federal anti-discrimination laws that serve as a floor of protection. Maine legislators, such as all of you, have voted in the past to make Maine's protections broader. When I do other presentations, I have loads of slides talking about that, but I decided to keep it brief for you. But an example is in employment. Most federal anti-discrimination laws apply if there are what we in Maine would consider to be larger employers, 15 or more. The Maine Human Rights Act applies if there's even one employee. Similarly, in housing, the anti-discrimination provisions of the Federal Fair Housing Act apply if there are, it's any rental property, but also owner-occupied rental properties that rent out 4 or more units or rent out 4 or more rooms. And in Maine, there are a lot of smaller units. The Maine Human Rights Act covers all of those plus owner-occupied triplexes. There are other exceptions that I'm not going to get into today, but I'm happy to talk about if folks would like. The education provisions are also fairly broad. They apply to preschools, colleges, public schools, charter schools, private schools. Now, you can't see my little title there, but the protected classes. So these anti-discrimination provisions apply if a person encounters adverse action or exclusion because of a protected class. Something about them that is innate, you don't choose about yourself, like race, color, religion, ancestry, gender, sexual orientation, disability. Sexual orientation is one of those ways in which the Maine Human Rights Act is broader than federal anti-discrimination laws. The Maine Human Rights Act was amended for the 3rd or 4th time in 2005 to include sexual orientation, which includes within its definition in the Maine Human Rights Act, sexual orientation and gender identity, even though those are different things, sexual orientation, gender identity, gender expression, they are all lumped together within the definition of sexual orientation. And again, I mentioned some of these things because there will be bills related to these later in the session. There are also a few specific areas of jurisdiction that have additional protected classes, like in housing. A person's use of public assistance, they can't be discriminated against in housing opportunities because of that. Familial status, and employment has some specific protected categories in addition to the general ones like whistleblower protection, genetic information, and retaliation for a workers' comp claim against a prior employer. So our process is someone files either an intake questionnaire or a signed notarized complaint. Our process actually requires a signed notarized complaint, but folks often start with an intake. We send the complaint to whoever they complain against and get back a response. When we have that, we consider, should the case go on? Is there a reason to dismiss it? Is it untimely, lack of jurisdiction, failure to cooperate? We offer a lot of cases. We have a lot of cases that resolve by mediation. We have a mediation program internally, a fee for service model that's very successful. Another way that cases end before an investigation is done is when the complaining party opts out. The programs like ours exist in every state around the country and work in tandem with federal anti-discrimination laws via a process of what's called administrative exhaustion. These programs serve the public interest by offering the state an opportunity to look at discrimination claims and also save courts from being overwhelmed with getting all these filings directly. But along the way, if we get to this point, usually about 2/3 of cases resolve, either by dismissal or settlement or being withdrawn by right to sue. Those that remain, we assign to an investigator, and each investigator, we have 6 of them out of a staff of 13 and a half. They decide how they need to proceed and what information they need. They analyze claims and apply the appropriate law. And then they issue an investigator report with a recommended decision. This is our staff. We are the staff, the professional staff. We provide our summary of the case and the evidence and the law that applies to the 5 volunteer commissioners that I mentioned earlier. Then we provide those reports and any objections to them to the commissioners. Commissioners hold public meetings about once a month. Now we do them on Zoom. And commissioners hear argument on any disputed investigators' reports. About 2/3 of our investigators' reports no one objects to. So the commission adopts those recommended decisions without argument. Some statistics about our cases, and these can be found. We have our annual reports on our website. We don't have the FY 2020 report yet. Our database is not being cooperative. I apologize. The data that you see from 2019 is fairly representative of a given year for us. We do have enough information to say that we had about 775 cases filed in FY 2020. And the percentages about employment, housing, public accommodation are more or less in line with what you see here for fiscal year 2019. So, these are not particularly different than they have been in terms of percentages for, I've been at the commission for 9 years. So they're more or less the same. In terms of what do people actually claim? Disability is and has been for years the most frequently alleged basis of discrimination. That has not changed in FY 2020. It's alleged in almost half of our cases. Retaliation based on asserting one's rights under the Maine Human Rights Act, and retaliation for making what a person says is a whistleblower report. Those are the next two most frequently asserted claims or bases of discrimination. And again, that has not really changed in 2020. Sex discrimination is the next most frequently alleged basis of discrimination. Again, fairly standard over the last 9 years. We are often asked how frequently sexual harassment is actually alleged. And generally speaking, harassment is alleged in about half of the sex discrimination cases that are filed. And I won't go down all the rest. They are about as one would expect. Age discrimination claims are going up every year, which is not really a surprise. It's given the aging population in Maine and our place as the oldest state in the nation. I believe race and color claims are in fact up from 2019, but we haven't had a chance to digest the statistics in great detail. How cases end. As I said, about a third of the cases end up going to an investigator's report. About 2/3 of cases fall out along the way by parties settling their claims, getting right to sue requests and going to court, or withdrawing or otherwise being administratively dismissed. Given all of our cases as a whole, people often ask how often the commissioners find that unlawful discrimination happened. For all of our cases, it's about 6%, but that's not really, I think, a representative statistic. If you look at all of the cases that we had investigators' reports on, so those are cases where the parties continued to assert their claims and defend themselves throughout the investigation. In the fiscal year 2019, it was almost 17% of those cases, the commissioners found reasonable grounds to believe that unlawful discrimination happened. Our agency has partnerships with 2 federal agencies, the EEOC, which enforces federal anti-discrimination laws, and HUD, which enforces the Fair Housing Act. We have partnership agreements whereby if someone files a complaint with our agency that falls under federal law, we do what's called dual filing. We send it to them and they consider it filed as well. That happens in reverse. If someone files a complaint with HUD in Boston that falls under Maine jurisdiction, they will dual file it with us. Usually we will investigate, and both HUD and EEOC have determined that our anti-discrimination law and our practices are substantially equivalent to theirs. So usually they will review and adopt our determination and pay us per case that we close. And that funding, it's not always reliable. It depends on how many cases we can close. Things like COVID affect our closure rates, as do personnel, but the money is significant. This is our agency budget. And if you look at the top, it shows our current budget, which is what we'll be going into the biennial budget with. And federal funds make up a substantial amount of our agency budget for work that we are required to do under state law anyway. So we're very grateful for those funds, and we have to work really hard to maintain that funding. But it does provide us a lot of opportunities. We do get grants, additional project-based grants from each of those funders that let us do work that we couldn't do otherwise. So that's actually all I have for a slideshow because I wanted to just sort of skim across the top, and I'm happy to answer any questions that folks have. I think you will see a good amount of Barbara and me during the session. When I looked at the list of 1,600 bills submitted, there are quite a few that relate to the Maine Human Rights Act. Not on that list was a bill that our agency has submitted. It wasn't submitted pursuant to the agency authority, but under that statutory obligation to provide recommendations about discrimination. And it is a virtual copy of a bill that died on the governor's desk at the end of the shortened session last year. It was the third of 3 agency bills that we had submitted during the 129th, and it is in virtually the same form as it was when it died. So we're hoping that that one will go quickly. So with that having been said, I really appreciate your time and what I know is going to be a lot of hard work. We are a neutral agency. We try really hard to be factual and to not pick a side. We are here for the law, and we try to be a credible source for you.
Thank you very much. That was a really thorough review of the Maine Human Rights Act and the work of your commission. Let's see. Do we have legislators who would like to ask questions? And actually, before we get to that, Barbara, did you want to introduce yourself as well?
Sure. I'm largely here to keep Amy in check. My name is Barbara Archer Hirsch. I am legal counsel for the commission. I do virtually all of the commission's legal work, from reviewing each and every investigator report that goes out to litigating claims on behalf of the commission and anything in between. So I will also appear before you when it comes time to testify regarding bills that come up, and am always available to answer any legal questions you might have.
Thank you. So we have about 10 minutes for questions. Committee members, are there questions for the commission? Representative Moriarty?
I think you are muted, sir. Nope, still muted.
Still muted, Steve.
Got it now, I guess. Yeah. I realize the data from last year is not in, but did you see any COVID-related impact upon your filings?
Yes, we do. And I meant to mention that we are tracking that. We've gotten about 65 complaints so far, but there will be more. Ever since this started, we have been anticipating a lot of whistleblower protection cases, a lot of disability claims. We are concerned about a flood of housing cases once the eviction ban is lifted.
Thank you.
Yep. And of those we have gotten so far, the vast majority relate to employment.
Okay.
Thank you. Representative Babbage?
Thank you, Madam Chair. Thanks for the review. Amy, it reminded me of my first major substantive speech in the legislature and its importance when we had a very close vote in the House regarding expanding anti-discrimination protections to gender preference regarding employment, lodging, and education. It was the votes of just 2 people that made that difference as to whether to kill it or not. So what I wanted to ask actually was in your listing of the categories of things you address, we've had an expansion of speech regarding license plates nationally. And I wondered if, in fact, any of that had come to you. In other words, if the Secretary of State had a request for a certain plate, I don't know if they have their own legal division, if they'd go to the AG, or if they would consult you. And I wondered if that was something that had happened or that you anticipated. Thanks.
It hasn't happened. I assumed that they would not get in touch with us. I assumed that they would rely on either their own counsel or the Attorney General's office. I think if someone was denied, I think people do file claims with us against, say, the Secretary of State's office, if if they're denied a license and they say that it's a violation because of a disability or something like that, there could be claims like that.
Thank you. Are there other committee members who would like to ask a question? I'm not seeing anything, but I'll ask just a brief question. Could you point out a couple of the differences between the protections offered by the Maine Human Rights Act versus the Equal Employment Opportunity Act and other federal statutes?
Sure. Well, actually, Barbara, do you want to field that one? You're a lawyer.
You're a lawyer too. Go ahead.
So I'll do, to me, among the most important, and there is not, among the many different federal anti-discrimination laws that EEOC enforces, the Civil Rights Act covers race, religion, sex. The ADEA covers age. I think major differences to me are in that the federal laws only cover larger employers, and Maine covers almost all employers. And to me, in Maine, given that there are so many small businesses, I think that's a really substantial difference. And another, among the other ones that I think is very significant is the coverage for sexual orientation, gender identity, and gender expression. And the fact that that has been largely not as dramatic as I think perhaps folks might have feared. So we've had 15 years of that being in the law, and it's been fairly standard business. There are many more differences. Barbara, do you want to mention the important ones that I have not thought of?
I won't cover them all. I think what I would want to stress is that Maine has led the way a couple of times. Amy has mentioned the sexual orientation and gender identity. Another way that Maine was a leader in human rights was a few years back when the definition of disability was amended. And our definition of disability was much broader than the Americans with Disabilities Act, and that led actually to the federal government using our statute as a model when they did the updates to the Disability Act a few years later. So I think that's important. It's still in our act that our law is intended to be interpreted more broadly with regard to disability. And I think that's important.
I would also mention that we have, as of last year, broader protections for pregnant employees, largely due to the work of Senator Carney and Representative Harnett. Some really great language that is broader than what is in the federal anti-discrimination laws. So, I mean, we've been really fortunate. The Maine Human Rights Act, we don't try to tinker with it very often, and it's pretty good. And we try to leave it alone as much as possible. So you don't generally see us here all that often asking for amendments to the Maine Human Rights Act.
Thank you for those thorough answers to my question. I was looking to committee members one last time. Does anyone have any final questions?
Well, you'll always remember us as the ones who got out of here quicker than expected.
Well done. Thank you very much. I think we are all set, and we are going to move on in just a minute to Pine Tree Legal Assistance. Before we do that, I think Representative Libby joined us just a couple of seconds after we finished our last round of intros. And so we're redoing introductions. Representative Libby, would you like to introduce yourself?
I don't see you.
Hi, I'm a Representative Libby from Auburn, and I represent District 64, which is Minot and part of Auburn.
Thank you. It's nice to meet you. We wish you all the best of luck, and from wherever you are, you're all in these different places. Thank you again for your time and attention, and let us know if you have questions going forward.
We will, and thank you for your presentation.
Thanks.
Bye.
Goodbye.
And I am going to turn the virtual gavel over to Representative Harnett, the House co-chair of the committee, for the next two presentations.
Thank you, Madam Chair, and welcome again, everybody. Our next presentation is regarding Pine Tree Legal Assistance, and I'm very happy to introduce a woman who I've known for almost over 30 years, and I've had the pleasure to work with her in different capacities, and I'm looking forward to her presentation. Before I begin, Nan, it looked like you were on during the introductions. Is that right? So you're
Yes, I was.
Okay, then I will turn it over to you and ask you as we start, did you save some time at the end for questions? Or would you like questions? So we'll hold the questions until the end of your presentation.
Well, I think that's fine, Representative Harnett. I mean, I also, I do not have a PowerPoint. Okay. I am not going to share my screen. So I will periodically pause, and if folks have questions about what I'm discussing, I'm happy also to take them as it comes up. The only prop that I like to bring to these meetings is this one, which is the 1883 list of all of the statutes and laws that existed in Maine at that time, which I think is a great reminder for all of us about how complicated our legal system has become since that time. We now have, I believe, 58 volumes and 7 or 8 pocket parts of the Maine revised statutes. It is hard for those of us who are lawyers to keep track of all of that. It is impossible for the public to keep track of all of that. And Pine Tree was formed in part to ensure that the lowest income people in our state would have a voice in understanding the laws and in enforcing their rights, because they were the least likely to otherwise be able to have someone speak for them in a civil proceeding. We opened our doors in 1967, so we've been around for a long time. When we opened, it was really because of private lawyers in Maine who were trying to provide free help to folks in their community, and they just could not stay on top of that opportunity, the requests. And it coincided with an opportunity from the federal government to provide funding for civil legal aid programs to start up in states around the country. And Pine Tree was the organization that was started in Maine to meet that need. We were one of the first programs to be statewide in scope, and we have continued to be statewide to the present day. We right now have 6 office locations around the state. That's changed at different moments in time. We've had more offices and offices in different locations. But our goal is to try and put our staff and our offices within an hour's drive of all of the district court locations, because many of the cases that we handle for Pine Tree clients involve being in district court. You should have a copy of the toolkit for constituent services that talks about the kinds of problems that we handle and how to make referrals to us. Right now, we have 62 people on our staff, and we also are always looking for volunteers. And we also use law students and sometimes college students to help expand our services so that we can reach more people. Because while 62 staff may seem like a lot, I think right now given what I've seen about income information in Maine, almost 1/3 of the people in Maine could be eligible for our services if they had a civil legal problem and they wanted help. We have a board of directors that has 24 people on it. Our original funding came from the War on Poverty. Under President Nixon, it was changed to the Legal Services Corporation, and that has been our primary federal funding source since 1974. We have added other grants. We started getting our state appropriation in 1983 as a result of funding cutbacks that we had at that time. And our state appropriation we've had every year since then. It increased, it almost doubled under Governor LePage and has been flat since 2015. And we are in the governor's budget at the flat level of $500,000 a year at this moment in time. We, to do our jobs though, we need lots more funding than that. So we have worked really hard, especially in the last 25 years, I would say, to really diversify our funding and to expand our ability to serve the people of Maine. So for instance, we have a grant from the IRS to provide representation to people with tax problems with the IRS. And there are a lot of folks in Maine that have those challenges. We have special grants to serve, many special grants, both through the state and the federal government to serve victims of domestic violence and sexual assault. And those at one point were large enough so that we could have people in every office doing that work. They've shrunk a little bit in the last couple of years, but we are still trying to be a primary resource for victims of domestic violence and sexual assault. And those cases come to us from the agencies, the domestic violence and sexual assault agencies around the state, as a referral, what we call a warm referral, directly to our staff, and then we reach out to the client to provide the support that that client needs. We have a grant from Housing and Urban Development to do housing discrimination work. So we will sometimes appear in front of the Maine Human Rights Commission on housing discrimination cases on behalf of people in Maine. And many other projects that I can talk about in a little bit. We also work really hard to make sure that people know about our services, because while I've been the director of Pine Tree since 1990, and I was a staff attorney in our Native American unit before that. And I grew up in Maine, so I tend to think that everybody knows about Pine Tree and knows what we do and knows how to reach us. The sad reality, of course, is that we are unknown to many people. And so we put a lot of time and energy into trying to make sure that people know when the problem they have is a legal problem and know how to reach out to us for help. And in pre-COVID times, we would do that work through a lot of local presentations and trainings and meetings with every group that would be willing to host us to come in. And so we will talk to CAP agencies, we will go to, we were a regular presence at the Maine Military and Community Conference that was held on an annual basis until COVID. We try to connect with really anyone we can think of, because so many people only associate lawyers with divorce and police matters. And so a lot of times people won't reach out to us if they have a problem with debt collection is a really common one. We worked very closely with the previous administration around poverty tax abatements. It really, the issues change over time, but we want people to try to reach out to us and to understand that they have rights. One of the other important ways we do that is through our program websites. PTLA.org was the first website that we launched. We launched it in 1996. One of the first things that we put on the website was information about property tax abatements that the state of Maine had just put in place. Our PTLA.org website is one of the most popular statewide legal aid websites in the country. We have a lot of information on it, and it's written at a 5th grade reading level so people don't have to navigate our lawyer language. So we have that. We have a kids legal website that we launched in 2004 to try and support the needs of Maine families and children and youth who were dealing with everything from emancipation issues to being homeless and not being allowed to enroll in their local schools, to issues of harassment between teenagers, the full range, the full gamut of those issues. So kidslegal.org is a separate state law specific website. And then because Maine has such a significant veteran population, and we know how to do websites, we were funded by the Legal Services Corporation to create a national website on the special laws and benefits specific to service members, veterans, and their families, and that's stateside legal. And we have continued to update and grow that website over the past 10 years since it launched. Let me think. So last year, just to put this in context for you, we had over 1.6 million visitors to Pine Tree websites in 2020. And they recorded, I think, something like 3.6 million page views of content on the sites. And some people are regulars and some people will just go there once and find what they need. But I hope all of you can help us make sure that your constituents know about those websites. And if you have suggestions on content that's missing or things that would be useful to the websites, I hope that you will let me know that. In terms of the clients we served last year, we handled 6,300 cases statewide. That is down from our usual number, and I think is a reflection of the impact of the pandemic and the fact that the courts were closed for several months. And so we were not going to court on cases for people. Or in an ordinary year, we'd handle almost 7,000 or more cases for people statewide. Of those cases, we also really prioritize doing what we need to do to solve the case. There are definitely services and opportunities for people to get a quick answer to a question, a sort of a yes/no answer, or a you should try this answer. But Pine Tree and our board made a decision a few years ago that we were going to prioritize full representation where we could. In an ordinary year, in 2019, I think we were able to close almost 40% of our cases with full representation. That was impacted by the pandemic again, because we were not able to get to court as much, but 24% of the cases we handled last year received full representation, meaning we did whatever we had to do to solve the problem that the client came to us for help with. And of the cases that received full representation, 95% of them were resolved in favor of our client, which I think is both a tribute to how great our staff is, but it also shows you if we had more capacity, I really believe that a lot of people have problems that if they had an advocate to speak for them, we could be helping more people, that folks just don't understand the law and they don't know how to articulate their own situation in a way that leads to a resolution. Of the clients we served last year, 58% of them were at or below 100% of the federal poverty guideline. That's the largest single category of our client population, are really, really low income people. A third were below 200% of the federal poverty guidelines, and 9% of our clients were above the federal poverty guidelines. And that 9% includes many veterans who may get disability benefits that put them above the income guidelines, but still don't allow them to access free legal help with civil problems. We have several specialized projects. Our Kids Legal website is supported by a Kids Legal unit. We only have 2 staff people in that unit, but they are amazing people doing great work. And if you have constituents who have children, especially that are having problems with schools right now, I would really encourage you to reach out to us. And to reach out for those constituents, you can just go through the local intake number for the office that is closest to your constituent for help. We have a specialized unit for Native American issues. I'm really pleased. We have our attorney in our Presque Isle office, Lisa Chase, chairs that manages that unit. But we have a Penobscot tribal member who is finishing up his last year in law school this semester, who will be externing with us and then moving into the role of staff attorney for the Native American unit in the summer. And we have a unit focused on the needs of agricultural workers in our state, people that come here seasonally for support, to help with everything from dairy farms to picking blueberries when it's possible to pick blueberries, and making wreaths and activities like that. And those numbers are on our list. There are other legal aid programs in Maine, and I hope all of you are familiar with them. Legal Services for the Elderly, Immigrant Legal Advocacy Project, the Volunteer Lawyers Project, the Clinic at the Law School. And I want to just be sure you appreciate how carefully we work in partnership with each other. So there is no fighting over the opportunity to serve a particular client. We have very clear parameters around how to maximize access to free legal services in Maine. And we work very hard to make sure that that happens. I mentioned the litigation piece. I guess the other thing that I would just really want to emphasize to all of you is, one, the challenges of the pandemic. I mentioned that we haven't been able to do outreach and trainings as much. Last year, we actually, for the first time in my history as a director, we paid to put ads in local newspapers around the state, especially in rural areas, because we were concerned that people without, especially people without good broadband, might not know that Pine Tree was still in operation and still available as a resource for them. And I think that helped increase our calls from Somerset County and Piscataquis County, and some of the other places in Maine where we don't have offices and that are a long drive from the nearest office. But we really want to find a way to get back to that. And so we will be trying to do some Zoom trainings and presentations to different groups this winter and spring. We are all hoping that it will be possible for our staff to start going out and interacting with their counterparts in Maine social service agencies going forward. Those of you who have been on this committee before know that we had hoped that we've had a project in place at Togus since 2015 that is an on-site clinic to provide free legal services to veterans who are referred to the clinic by their doctors and nurses and social workers at Togus. And it's a wonderful model, and it has really allowed us to serve a lot more veterans than would have come to us otherwise. It has been disrupted by the pandemic. We are hoping that we can go back when those restrictions ease. We also continue to look for funding support for that clinic. We had gotten close, as I said earlier, in getting support for $150,000 Part B supplement for the clinic, and that sort of was left on the table when the legislature adjourned last March. And I'm hoping at some point we can revive that. But I'm certainly very grateful for the continuation of our current funding that is in the governor's budget. The final thing I wanted to say, and then we'll have lots of time for questions, is as some of you know, A condition of our Legal Services Corporation funding, which Pine Tree receives, is that we are subject to a lot of very specific rules. Among those specific rules are that we can never come to you and say, here's a problem with the law that we think you ought to change. We are not allowed to lobby. We are not allowed to engage in partisan activities. We are a strictly nonpartisan legal law firm for low-income people. But that said, if it is helpful to members of this committee or to your colleagues in the legislature to ask Pine Tree to lend our expertise on anything from domestic violence to foreclosure to eviction to housing discrimination. There are lots of issues that we do have staff experts on. If you are kind enough to email me and request that we lend our expertise, then in that circumstance, we can provide it. But otherwise, you will not see us in Augusta. We will be trying to navigate the complicated schedule of, just docket calls by telephone and mediations by this and court hearings by that, which is what is mostly preoccupying our staff time at the moment. And I'm happy to answer any questions.
Thank you very much, Nan. And you get the prize for being a lawyer who doesn't have to use all of her time speaking. And you've saved a little over 10 minutes for committee members to ask questions. And I'd like to open it up to committee members. And I'll use the same approach that Ann used and hope I do as well, which is show your hand and I will call on you. So you can address any questions or comments you have to Ms. Heald. Representative Babbage and then Representative Reckett.
Thank you, Mr. Chairman. Welcome. Thanks so much for coming back to us. I just, first of all, wanted a clarification on some of the data that you shared with us. I was taking some notes, and you had mentioned that I believe that 1/3 of your clients are 200% of the poverty guidelines, but you mentioned 58 and 9, and I missed the characterizations of which is which. Could you help me with that?
Absolutely, Representative Babbage. So this is our 2020 client population, and we track lots of information about our clients. 58% of those clients were below 100% of poverty. 1/3 were between 100 and 200%, and 9% were above 200%.
Above 200. Thank you very, very much.
Mm-hmm.
Is that it, Representative Babbage?
It is actually.
That's unusual.
For the moment.
Yes. Thank you. I can now mute you from the control booth here. Representative Reckett.
Hi, Nan. My question is probably not really a question, but something I think that this committee needs to know. And you mentioned the interactions that you have had with Volunteer Lawyers Project. And I'm going to try to say this part without crying, because the volunteer legal community this year, since the epidemic had started, just lost a heroine, not to COVID itself, but she was the head of the Volunteer Lawyers Project. And I think some of you have seen her in passing up here over the years, a woman named Juliette Holmes Smith, who started her career working for me, actually, at Family Crisis Services, until I talked her into going to law school because she was too argumentative to supervise. And she turned out to be a spectacular lawyer and did so much incredibly important work. And her loss last year was just dreadful. And as you could see, I have not succeeded in not crying. But I don't want us to forget her. And I don't think she will be for a long time. But she was just an extraordinary woman, an extraordinary advocate, particularly for victims, from my perspective, domestic violence victims, but for everybody who was involved in seeking services from Volunteer Lawyers Project. She was really a star, and the state is much poorer with her passing. So I just wanted to mention her so that she would be in this room right now in spirit. Thank you.
I can add to Representative Reckitt's comment. Juliet, after she graduated from law school, came to work at Pine Tree and was our domestic violence attorney in the Portland District Court for many years before she became the director of the Volunteer Lawyers Project. And one of our favorite stories about Juliet is a day in the Portland District Court when the judge did not come out and they did not start proceedings because Juliet was not in the room. And our staff person had to explain that they were there in Juliet's place. And then the bailiff said, all right, I'll tell the judge we can get started. It is, I think, underscoring what an incredible presence Juliet has and continues to have in shaping all of our understanding of the horrific problems of domestic violence and sexual assault and our responsibility as a legal community to address them.
Thank you.
Thank you, Representative Reckitt, for bringing up Juliet. I had the pleasure of working with her when she was the executive director of VLP, and she was truly a remarkable woman, and it was a tremendous loss to the legal services community and the legal community in the state of Maine. Are there other questions from committee members? I'm looking for hands. Senator Keim.
Mr. Chair, I recognized your comment that you were able to shut off Representative Babbage's microphone, and I appreciate that moment that you took that to share that. One of the questions I had was, I'm hearing from a lot of people across the state, but even but especially my own constituents as well, concerned with that they're not able to have evictions at this time. But interestingly, they point to Pine Tree Legal as one of the problems because not necessarily during the pandemic, but before this, as offering free legal aid to the tenants, and then they, of course, don't get free legal aid, and so it's making it more difficult. And what I'm seeing is I'm hearing pretty severe stories, and thankfully the acting Chief Justice heard one as well. But I'm hearing these as well. Like, we have some really dire situations going on right now with landlords. And so I just wanted to hear your thoughts around the extra issue that landlords are saying is a problem because of the services that are unevenly offered, I guess, so to speak, because most landlords I know, they're not wealthy, right? It's just a side thing for them, or maybe just their sole income. So yeah, just wanted to hear your thoughts on that.
I mean, Senator Keim, it is true that we can only represent one side in these proceedings. And while landlords, I certainly know of landlords that are economically challenged in the ways you describe. Again, as my statistics convey, the people that we're representing don't have assets and have very limited incomes. And so I can't change that dynamic. I can share with you that we have had landlords in the past who have been grateful for the very clear information on procedures that is on the Pine Tree website that is accessible to them to understand how to proceed legally in addressing tenant situations. And I know that there are resources, again, they're not free, but I know the Maine State Bar has a lawyer referral program that will provide consultations for landlords at a fixed cost of, I want to say $30 for a half an hour of advice. So I think there are resources out there, but I don't want to mislead you into thinking that Pine Tree can correct that problem. I also think that our presence may seem larger than it is. We have many, many people that we are having to say no to because we just don't have the staff capacity to help them. And we've seen some bad actions by landlords around the state that would concern all of us, I know. So I think finding resources for both sides would be ideal, because then you can resolve cases quickly.
Thank you. Senator Keim, any follow-up questions? Thank you. Representative Babbage, you notice I have not mastered how to actually.
This is a rebuttal to Senator Keim. No, I actually, thank you very much, Mr. Chairman. Ms. Hield, I wanted to, this is the first time we've seen anybody from Pine Tree Legal since COVID began. And obviously, many of us have been very concerned about the potential ramifications to housing and to domestic violence. And I wondered if you could validate that as to it coming to your attention. What have you been able to document as a data-driven difference in what's transpired because of the ramifications of COVID regarding the problems that have evolved from domestic violence and the housing situation?
Representative Babbage, I'd probably want to follow up with you and with other members of the committee to talk to my staff experts on that. I mean, I think one obvious problem is that people were not able to leave their homes in domestic violence situations. And that continues, I think, to be a challenge for many of the people that we work with, and is a real concern for our staff.
That makes sense to me, and it's been a great concern, but I don't know if it's been warranted in the reality of those that are dealing with the problem. That's what I had hoped to hear. Thank you.
Well, let me talk to my family law and victim rights staff, and I'm happy to follow up with you after this meeting, Representative Babbage, and or to share the information with the committee chairs if others are interested in this topic too.
Thank you very much.
Absolutely.
Other questions? If not, we have 1 minute left. I have a question, Nan, and it may be something you'll have to get back to us on, but you talked about outreach and how important outreach is for you to make contact with your clients, often clients who don't know anything about you. And outreach I cannot think of a population that outreach is more important to than farm workers. And I'm curious as to how you met farm worker clients during COVID. Is that something that you could get from the farm worker unit? Because I'm sure they had to recreate the work that they did, because without outreach, farm worker law is almost impossible to practice.
I absolutely, Representative Harnett, can check with our staff and share some information on their workarounds. I do know that we ended up investing in something called WhatsApp, because a lot of agricultural workers have that application on their phones, and it makes it easier to communicate with them. And so we added that, and we did do a lot of Zoom trainings with the other participants, the Maine Migrant Healths and Maine Migrant Educations and State Department of Labor staff that support agricultural workers, to try and compare notes and brainstorm on how to make services available. But I'll follow up and give you a more thorough answer to that question.
Thank you very much. I think WhatsApp even can translate on some of its platforms, which is remarkable. I don't see any other hands, so if there are no further questions, I'd like to thank Ms. Hield for her presentation. Look forward to her providing the additional information we requested, and wish you the best going forward. And I would just repeat that if you have legislation that could benefit from the expertise of legal services attorneys, they are a tremendous resource. You just have to ask through their executive director whether or not it's possible for them to participate in this process. So thank you, Nan.
All right, thank you all.
And our last presentation of the day, I think we have two people. This is from the Maine Indian Tribal State Commission. My agenda shows that we have Paul Downing, who's the chair of the commission, and Paul Tebow, who is the managing director. And before I introduce you, Mr. Tebow, were you able to hear the introductions earlier from the committee members so you know who is who here?
I'm afraid I didn't hear all of them.
Okay, then I'm going to quickly have people introduce themselves, and there's no order to this list. It's just the list I have in front of me. My name is Tom Harnett. I serve as the House Chair. I represent House District 83, which is the town of Farmingdale in the city of Gardner. Senator Carney.
Hi, good afternoon. I'm Ann Carney. I represent Senate District 29, South Portland, Cape Elizabeth, and a little sliver of Scarborough.
Thank you. Senator Sanborn.
Good afternoon. My name is Heather Sanborn. I represent District 28, which is half of Portland and half of Westbrook.
Thank you. Senator Keim.
Good afternoon. I'm Lisa Keim. I represent Senate District 18, which is northern Oxford County and 2 communities in Androscoggin.
Representative Babbage.
Hello again. My name is Chris Babbage, House District 8. Most of the town of Kennebunk, but only one of its beaches.
Representative Downs.
Good afternoon. I'm Kathy Downs. I represent District 130, which is Bucksport and Norrington, and this is my first term.
Thank you. Representative Hagan.
Thank you, Mr. Chair. I'm David Hagan. I represent House District 101, Hamden and Newburgh.
Thank you. And Representative Libby.
Hi, Representative Laura Libby. I'm from Auburn, and I represent District 64, which is part of Auburn and all of Minot.
Thank you. And Representative Moriarty.
Hi, Steve Moriarty, representative from District 45, which is Cumberland and part of Gray. And a quick question for Paul. Did you go to Bowdoin?
Yes, I did.
It's been decades, Paul, but we were classmates.
Yeah, that's right, we were.
Good to see you.
Lovely reunion. Representative Newell.
Good afternoon, Paul.
Afternoon.
Newell, representative for the Passamaquoddy tribe.
Thank you. Representative Poirier.
Good afternoon. My name is Jennifer Poirier. I represent District 107, which is all of Skowhegan and a small part of Madison.
And Representative Reckitt.
My name is Lois Reckitt. I represent District 31, which is the ocean end of South Portland. This is my third term in the legislature and my third term on judiciary, as well as my third term on criminal justice. So I'm a glutton for punishment.
Thank you. And Representative Sheehan.
Good afternoon, Paul. I'm Erin Sheehan, and I represent House District 12. That's downtown Biddeford, and it's my first term in the legislature. Good to meet you.
And I just want to introduce some other folks that you see the Hollywood Square boxes of, because the committee could not operate without them. We have our analyst, Peggy Reinsch, and also our analyst, Samuel Seneft, and the woman who keeps everything running in the Zoom world, our clerk, Susan Panett. So that's the entire team. So with that, Paul, I will turn it over to you and would ask that if you can possibly leave some time at the end of your presentation for questions, that would be great.
Yes, and I believe our new chairperson, Paul Downing, will be joining us, but I'll launch in. But it's a pleasure to, all of you, I already know it's a pleasure to see you again. even if it's by Zoom. And it's very nice to meet the new members of the committee. So I'll probably, I'll jump in with some things that I was, obviously Paul was going to go first, but I'll steal the show, I guess.
Yeah, I'm not seeing him here, unless maybe Susan Soupy could check if he's in a waiting room. I don't know if we even have a waiting.
In his job, Paul deals with emergency management issues, and he's been extremely busy with issues up at the the reservations in Washington County. So it's possible that he's gotten tied up. So I'll just introduce myself briefly for those who don't already know me. Paul Thibault. I've been the director at the commission now for about 2 years. Before that, I was, I'm an attorney, and I spent about 30 years working in Indian country in various places as a legal services attorney, including a number of years for Pine Tree Legal, the best legal aid program in the country. And I worked in a lot in the reservations in Minnesota, in Maine, but also in Minnesota and South Dakota and some other places. And I want to say up front that if you have questions as I go along, please just feel free to just pose questions rather than not feel like you have to wait till the end. I will try to leave adequate time, but I'm a lawyer, so I'm not going to repeat the materials that were in the one-page overview that I sent in. I hope you all have had a chance to look at that. So I'm not going to read that or go through everything that's in there. But I do want to emphasize and pick out some things and expand on them a little bit. First of all, I want to make sure I mention, because Paul Downing was going to mention, that we've just learned that the Governor Mills has nominated a state commissioner to fill the seat that was left vacant because of the unfortunate death of Michael Pearson, a former legislative colleague. So we just hope that the committee will be able to, expeditiously act on that for confirmation, so that we can get back to full speed, to full strength, because we've been down one member now since last March when Mike passed away. So some other things that I just want to emphasize. MITSIC has a very broad purview, a wide range of issues that MITSIC has statutory authority to review and make recommendations on. Our authority as far as dispute resolution is limited. We don't have statutory authority for dispute resolution, but we do have very broad purview in terms of the types of tribal state issues that we can look at, and which MITSIC has over the years, over its 40 years history, looked at many different kinds of issues. Natural resources has always been a priority, an issue that MITSIC has a lot of involvement with, but there's a very wide range of other things that MITSIC has worked on in the past. For example, MITSIC was the entity that was the convener for the commission that was created to promote Wabanaki studies back in the early 2000s. MITSIC was very involved in mascot and nickname issues, especially including the town of Wiscasset, which had the Redskins mascot. And MITSIC, another example of the range of issues, is that MITSIC played an important role in promoting the development of a new policy by the Department of Corrections that allowed for the practice of native religion within Maine's prisons, and resulted in the first ever sweat lodges being conducted, within the boundaries of the Maine State Prison. So it's just an example of the range of issues that we have tried to work on. And I mentioned dispute resolution, and I bring it up because I think there's a certain amount of misinformation or, expectations that aren't justified, because MITSIC has never had statutory authority to do dispute resolution. And although there's been sort of, I think, an expectation that MITSIC would somehow, play that role without necessarily having the statutory authority. As a practical matter, there is no obligation on the part of any of the state or tribal governments to bring issues to MITSIC, or to ask MITSIC to resolve disputes. MITSIC gets involved in that way only if the state and the tribes want MITSIC to do that in a particular situation. There was discussion, or at least some talk a couple of years back about possibly amending the Settlement Act to invest a specific dispute resolution authority in MITSIC. The legislation that was proposed last year did not propose such a role for MITSIC. The separate piece of legislation, which was LD 2118 last year, did envision a role for MITSIC to study and recommend regarding an appropriate dispute resolution between the state and the tribes, and perhaps that will be carried over this year. I would say this, that MITSIC as an entity doesn't necessarily seek to take on that formal role of dispute resolution unless the state and the tribes want MITSIC to play that role. But if MITSIC were invested with that role, I believe that MITSIC would embrace it and do its very best to function in that role. One of the things MITSIC has been involved with them before, and possibly could be again, is to promote the issuance of executive orders on consultation by the state governor. Both Governor Baldacci and Governor LePage enacted executive orders, although Governor LePage withdrew his because of some issues that came up. But so that is something that MITSIC may advocate for, but just the shortcoming of executive orders is that they aren't permanent, and from one administration to another, they can be changed or they can be eliminated altogether. So they're not really a substitute for a permanent institutionalized process and structure for tribal state consultation, which MITSIC has always believed is the best way to address and resolve disagreements between the state and the tribes, is to have a real consistent process of tribal and state consultation. The overview I gave you mentioned that MITSIC has always struggled with limited resources. I mean, in recent years, the state has increased our MITSIC's funding, and that certainly has been helpful. Although MITSIC has been flat funded for a number of years now, and that's the new biennial budget would continue that flat funding. So at times MITSIC has been confronted with very difficult choices because of limited resources. And I'll give a good example. A few years ago, the Judiciary Committee expressed interest in MITSIC doing a study to explore some aspects of the drafting of the settlement, and particularly issues relating to the addition of Section 1735B in the federal statute. That's the section that limits the applicability of new federal laws that would benefit tribes, and they don't apply, and because of that provision, they don't apply in Maine unless Congress specifically provides for that, which seldom happens. So MITSIC undertook to contract with Suffolk University, the Indigenous Law Program there, to do that study, and it turned out to be a good study. It's I think it's been well received. The task force by the committee and by the task force. In fact, the task force on the changes to the Settlement Act went back to the law clinic at Suffolk and asked them to do some follow-up for the task force. So we feel MITSIC feels really good about having, arranged to have that study done. But the reality for MITSIC was that it drained the resources to the point where MITSIC at that time was not even able to keep a full-time executive director. And it had to reduce the current director at that time to just a part-time role because of the cost of contracting for that study. MITSIC went through a period of relative inactivity, as a lot of you know, during the latter part of the LePage administration, when state seats on MITSIC were not filled. We geared up when I was hired on. We geared back up in the middle of 2019. Governor Mills appointed a full new slate of state commissioners, and MITSIC's activity level has definitely increased very substantially. And some of the things that MITSIC has been able to do, even with the current resources. And I should mention that because of that period of inactivity, MITSIC did accumulate some carryover funds, and those carryover funds have allowed MITSIC to take on some things that it just really never had the resources or wouldn't otherwise have had the resources to do. And over these last, the last 18 months in particular, MITSIC has commenced a study under section 6207 sub 8 of the Implementing Act that involves the impact of non-Indian activity on the ability of tribal members to exercise the sustenance rights that are protected in the settlement. And that section has been in the Settlement Act from day one. Realistically, MITSIC never really had the resources to engage in any systematic study under that section. So that's something that is ongoing, that we're working on in MITSIC now, and we're able to do it, frankly, because we're using carryover funds. We recently completed a study, which again we contracted for independent research regarding the removal from the printed Maine Constitution of Section 10, Article 10, Section 5, which is the part of the Constitution that dealt with the state of Maine taking over the obligations from the state of Massachusetts regarding the tribes in the former District of Maine. In 1876, that language was removed from the printed copies of the Maine Constitution. It remains in effect, but is no longer part of the printed Constitution. So MITSIC was asked to conduct basically a study of how that came to be, and that was recently posted and is available on our on the homepage of our website now, and I'd be more than happy to provide it to any members of the commission who would like to have that. Another very specific thing that MITSIC accomplished in the past year was to prepare an amicus brief in the Penobscot River litigation. MITSIC explored its history and what its positions had been and its understandings had been on that issue. And ultimately, the commission, all the commissioners, state and tribal, voted unanimously to issue that amicus in support of the position of the federal government and the Penobscot Nation. And we've also, as some of you know, we've shown, appeared in Augusta to testify on a number of different bills over the last couple of years. MITSIC recently completed a new work plan, and which identifies both ongoing projects and new projects that we would that we intend to pursue for the balance of this fiscal year and probably for the balance of the calendar year. That one of the things on that work plan is to review, the current legislative proposals, so MITSIC may be issuing specific, recommendations or positions on the various legislative proposals in this session. Some of the other items that are in our work plan include, trying to help rejuvenate the efforts to promote Wabanaki studies in Maine schools, something that MITSIC was very involved in the past, to increase knowledge in Maine of the UN Declaration on the Rights of Indigenous People and the companion state resolution that was passed in 2008. We're trying to play a constructive role regarding solving the water quality problem that exists at the Pleasant Point Reservation and in the city of Eastport. And we will probably explore some issues arising from the Permanent Commission, the report of the Permanent Commission on the status of indigenous peoples. I'm not getting the exact title of the commission right, but I want you to all know that there are materials available at our website, and a number of key reports are available right on the home page of our website, which is at mitsic.org. For instance, the Suffolk report that I referenced is there. The amicus brief, all the briefs in that Penobscot River case are actually on the website on the home page. The 2008 report of the Tribal State Work Group that MITSIC played a key role in staffing, that's on our website. There are many different materials that are available, and in addition to just telling you about the website, I'm more than happy to provide materials directly to the committee members. So that's basically what I wanted to present, and I hope I've left enough time for some questions.
You have, Paul, and thank you. And I just want to tell the members of the committee, particularly the newer members, you will learn a lot about tribal-state relations on this committee. The committee did a lot of work in the 129th with the task force that was put together, and MITSIC was very involved in that, dealing with issues of sovereignty and tribal-state relations. So this might have seemed like a lot of information that is difficult to digest, but you will have lots of time to be fed more of it as we go through this process. It's part of Maine's history and its present day experience. So with that, are there questions for Mr. Tebow with the time that we have remaining? Senator Carney?
Paul, you kind of answered this question already, and thank you, Chair Harnett. But I did want you to highlight a couple of the reports on MITSIC's website, which, for members of the committee, as like myself, I haven't been on this committee before. I feel like there's a lot of information and background I need to learn regarding the tribal sovereignty bills that we're going to be hearing this year. And so I reached out to Paul earlier, and he suggested a couple of the pieces of information on the website. But Paul, if you could just highlight a couple that you think that it would be helpful for us to look at. And I'd also encourage members of the committee to go back and look at some of the testimony from the 129th as well.
Yes, thank you, Senator Carney. I guess in particular, I would encourage those who haven't looked at that Suffolk University study that was completed in 2017. It's entitled I think the drafting and enactment of the Maine Indian Claims Settlement. It explores some issues that had come up at various times, and in particular in conversations with members of the Judiciary Committee. And one issue in particular that was that study goes into in some detail is how the Section 1735B came to be added to the federal piece of the settlement. For those who, if any of you don't know, the settlement legislation consists of both a federal law and a state law, and the settlement wasn't possible without having a federal companion to the state law. And that section, 1735B, was added very late in the process, several months after the Maine legislature had acted on the Maine Implementing Act, the state portion of the settlement. And it was added to the federal statute. And it basically says that federal laws passed for the benefit of tribes or Indians after the 1980 settlement will not apply in Maine if they would affect the jurisdictional structure that was created. Basically, if they could affect the jurisdictional authority of the state of Maine. I'm not getting the wording exactly, but that's the basic idea. And we were asked to look into that because it never really was all that clear how that provision, came to be added sort of very late in the process. And it's an important issue because a lot of federal laws passed since 1980, have bypassed Maine and the Maine tribes. And some of those laws would actually probably benefit both Indians and non-Indians if they were applicable in the state of Maine. So I'd encourage you to take a look at that report, and in particular that part of the report. And I would again note that as part of the task force process, the group at Suffolk that did that study, and the professor there who was the primary author of that study, they were asked to do some follow-up work to identify for the task force federal laws that had been enacted since 1980 that had not become applicable to the tribes and in the state of Maine. And it's a long list of laws enacted after the settlement that would benefit tribes, and I believe, and based on my experience in Indian country, that many of those laws would actually benefit in a lot of ways the surrounding communities, the non-Indian communities that are adjacent to the tribal communities. So I definitely would encourage you to look at that report. And again, I'd be more than happy to just send it to anyone who wants it. And another one that's right there on our homepage that would, I think, be real useful for background is the report of the 2008 Tribal State Work Group, which was staffed by MITSIC. A lot of the same issues that are being discussed, now in terms of the pending, legislative proposals were also discussed, at considerable length as part of that Tribal State Work Group that went on back in, I think it was 2000. I think it was completed in 2008. But so it doesn't cover the full range of issues that are now proposed, but it does have some really helpful information about, especially to understand sort of the tribal perspective on the settlement and the problems that have arisen for the tribes under the settlement, and on the other side, some of the state perspective. For instance, John Patterson, who was a primary negotiator for the Attorney General's office, he testified to the Tribal State Work Group, and Tim Woodcock, who was on the staff for Senator Cohen, and very involved in the passage of the settlement. He also testified at the Tribal State Work Group. And then, of course, a number of the a number of the tribal negotiators who were still with us at that time testified as part of the tribal state work group. So I would encourage you to, to look at that report as well for background.
Thank you very much.
Anything else, Senator Carney?
That's all, but I think I might have copies of both of those reports that I can circulate to the committee if people would like them.
Yes. Are there other questions for Mr. Tebow? Representative Babbage and then Representative Reckett.
Thank you, Mr. Chairman, and thank you, Mr. Tebow, for being with us again. I think I had two questions. I think one of them you pretty much addressed. I'm excited that MITSIC is back in operation, and but I was unsure about. I always thought it was a wonderful beginning, at least, for an official forum for collaboration between the tribes and the state of Maine. But I was unsure as to what you could do about any consensus that you might come to. And I think you've explained a little bit about that. I don't know if you have anything more to say, but the question that I have remaining, I know the Micmac population in Aroostook determined themselves not to be part of the settlement. But I think of MITSIC as being the primary conduit for state and Indian affairs to be discussed. And I wondered if you could tell me if there's any consultations with the Micmacs, or, I mean, it being one of the 4 federally recognized tribes in Maine, I wondered how much MITSIC is able to deal with all of that input that we would seek with our tribal citizens. Thanks.
Well, you're right that the Aroostook Band of Micmacs is not part of the 1980 settlement. They actually subsequently, with the help of a lot of work by Nan Heald, were able to secure their own federal settlement law in, I believe it was in 1991. So the Aroostook Band of Micmacs has never been officially, a member of the Tribal State Commission, although they do have ex officio status in our bylaws. The vice chief, Richard Syllaboy, participates often with us, but they have been, sort of a separate case. The First Circuit Court of Appeals issued a decision. Well, it's getting kind of old now. I think it may have been back in 2007, that sort of analyzed, the extent to which the 1980 settlement, applied to the Micmacs in Presque Isle. They have considered joining, the implementing act at times, but have chosen not to do that. They did participate fully in the task force, but they do have a separate status that hasn't at this point been, equalized or reconciled with the status of the tribes that actually participated in the 1980 settlement.
You're muted, Chris.
Thank you. May I have one quick follow-up with regard to that? The Micmacs are a New Brunswick and Aroostook population, and I know the Passamaquoddies are also have citizens in both, and Maliseets, right? Not probably not so much the Penobscots, although members of the Penobscots who are not in the state of Maine are still official members of the tribe, I believe, as far as voting. So I just wondered if when we talk about Maine's Passamaquoddies or Maine's Maliseets, Is there a dichotomy between Canadian tribal members and Maine tribal members, or is the organization of the tribes inclusive of either side of the border?
Well, I might, on some specifics, I might defer to Representative Newell, with respect to the Passamaquoddy, but basically the recognized tribes in Maine, the four federally recognized tribes in Maine function, governmentally separately from any Canadian, bands, or they have, the Canadian bands have their own governments, and so in a formal governmental sense, they are they're very distinct, and they have, the bands here have the tribes here have their relationship with the federal government because they're federally recognized, and they have a relationship with the state pursuant to the settlement. Their counterparts on the New Brunswick side have their own relationships with the province and with the federal government, the federal Canadian government. But there's a lot of connections on other ways, between folks who are, from the, who have relations on both sides of what, to them is just the medicine line that was created, between, the two countries. But there's still a lot of strong cultural and social connections between Passamaquoddy people, in Maine, and Passamaquoddy people just across, the bay, in New Brunswick, and the same for the Maliseets and the Micmacs.
The reason for my question, from a state perspective, was trying to determine if, I don't know, an educational allocation for a particular tribe had a specific identifiable population that it was going through, or is the membership fluid across the border? That's what I was partially getting at, I think.
Well, I'm not sure I can answer that accurately. I mean, the membership determinations under federal Indian law are absolutely, determined by the tribes themselves, so I'd be getting into slippery ground, I think, if I were to try to field questions specifically about dual membership or that sort of thing, or transferring membership, because I don't really know all the ins and outs of that.
Thank you very much.
Are there any other questions?
They're Representative Record. I'm sorry, I was unable to unmute myself.
I got that. I have a question, Paul. Do you see any increase in the role of MITSIC as a result of the absence of Donna Loring as the ambassador between the governor's office and the tribes?
Well, I think that's a good question. I guess we don't know the answer to that at this point. It's certainly I guess it really depends on whether the governor is going to put someone else into that position. She has indicated that, I think she said that, Donna Loring was kind of a unique person, to, fill that role. But I think that there's the possibility that, MITSIC could take on, some of that. Because I think as a practical matter, MITSIC did some of that before, when there wasn't, a special advisor to the governor. At various times, MITSIC has played that sort of intermediary role between the governor's office and the tribes. For instance, the the assemblies of governors and chiefs that happened back, at the time of the Bell-Bachi administration. I mean, those were, I think, things that probably would have fallen to someone in Donna's position, but now the question is, would it be more appropriate, would it be appropriate now for MITSIC to take back that role? LD 2118, as you may recall, has specific provisions that would have, authorized MITSIC to convene assemblies of that nature again, and both with the legislature and with the executives. And so I guess it remains to be seen whether or not MITSIC will be asked to take on more of that. And I would say this, and I meant to say this earlier, that and it's mentioned in my overview, but we have a very talented group of people on MITSIC right now, and I think that MITSIC is, in many ways, an underutilized entity at this time. When you look at the range of experience and knowledge and skills and backgrounds that we have on our commission, both on the state side, on the tribal side, there's a lot of talent there, and I think that both the state and the tribes could make more use of MITSIC. We have things that we're working on, and we will continue to work on those things that are within our statutory purview. But as far as getting in between the state and the tribes, MITSIC as an entity respects the basic idea of government to government communication, and we don't seek to insert ourselves when when that's not what the governments want. But MITSIC is very open to playing that role of promoting communication and effective consultation if the governments want us to do that. I hope that's somewhat responsive to your question.
Are there other questions from the committee or comments? Seeing none, I want to thank you very much, Mr. Tebow. It's good to see you again, Paul.
You too.
And I'm sure we'll be seeing a lot of you over the next 2 years, and I look forward to it.
And I apologize. I'm sorry that Paul Downing wasn't able to join us. Paul was selected in October as the new chairperson for MITSIC, and I was really looking forward to you all being able to meet Paul on this Zoom. Hopefully we'll have another opportunity before too long for Paul to introduce himself.
We will make certain that that happens. I appreciate your time.
All right, thanks a lot.
Thank you, Paul.
Hey, Paul.
Thank you, Senator Kearney. Have a good day.
I just want to, I'm going to turn this over to Senator Carney to close this out and talk about next week, but it received a message from Representative Newell that I think raises a very important point. And if I was guilty of this, I apologize, certainly, but we should never be referencing, quote, Maine's '(s) tribes. Maine does not possess the tribes. The tribes were sovereign nations long before we set foot on this turf. So let us all keep that in mind. And again, if I spoke in that way, I apologize.
If I may, Mr. Chairman, I think I might have said that, and I could have said the 4 federally recognized tribes within Maine, which is my intention. Thank you.
Thank you. So I'm looking at my screen and going to turn it over to close this out to Senator Carney. And thank you all for your thoughtful participation this afternoon.
Thank you, Tom. I will be very quick because everybody has put in a tremendously long day. Thank you all for your excellent participation, your attention, your great questions. Quick thing about Tuesday, we are starting to meet at 12. We don't have anybody on our schedule until 12:20. And so I'd like it if we could use that first 20 minutes to do two things. One is that we have a bill that has been referred to us that should really be heard by criminal justice and public safety. And there are a couple of different ways to re-reference the bill, but given where it is, because we've actually already scheduled it for a hearing, the easiest and best thing to do would be for us as a committee to re-reference it. It is LD 15. It underwent extensive hearing last year in the Criminal Justice and Public Safety Committee. So take a peek at that. And then in addition, we need to adopt our committee rules. And so we will have to continue our conversation on the rules and then decide what we are going to adopt for our committee rules. So that may take us a little bit more than 20 minutes, but we'll see how much progress we can make. And I hesitate to open it up for questions because everybody has already put in a hugely long day. But if there's something that can't wait till Tuesday, just unmute yourself and ask away. Looks like everybody's okay. Thank you all so much for all your hard work today.
If I could just one last comment, if anybody is not tired of Zoom, which that might be a foolish question to ask, there is a subcommittee meeting of the Maine Commission on Indigent Legal Services coming up at 4:45 if you want to learn more about their work. Thank you all very much.
Thank you, Tom.
Bye, everyone.
Thanks, Ann. Take care.
Thanks a lot.